Please rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear, all persons having business with the Appellate Division. Draw near for your attendance and shall be heard. Be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. Today, we have close to 7 hours of argument that have been requested. So I'm going to ask that you bear that in mind when I call the calendar. Remember that we have the briefs, we have your record, we're fully familiar with the facts of the cases, so please ask only for the time that you'll need to make your arguments. And I will call the calendar now. People versus Ryan Conyers.
Good afternoon, Your Honor.
Good afternoon. Okay. Are you asking for rebuttal? You didn't say anything.
Yes, 5 and 2, please, Your Honor.
5 and 2 and 5. Thank you. Golub versus Altchek.
Good afternoon, Your Honor. Leslie Corwin, on behalf of the appellant, I request 7 minutes on the main argument and 3 minutes in rebuttal.
Sean Rickman of McLaughlin and Stern, respondent, 10 minutes.
I'll do 5 and 2 and 5. Raymond F. Submitted. Sackis versus 240 East 46th Street.
Good afternoon, Your Honor. Appellant asked for 5 and 2. For respondent, Bruce Ressler, and I request 6 minutes.
Is there another part? 5 and 2 and 6. Thank you. Gentile versus Wegman.
Good afternoon, Your Honor. Heath Oldwood for the appellant to request 10 and 5, please. Respondent Wegman request 5 minutes, Your Honor.
5 and 2 and 5. Thank you. Oh, I'm sorry. Yes. 5, 2, 4, and 4. People versus Gerard Torres. Submitted. Lakia versus Volchanek. And is there another party? I can't see. There was no other party on this one. Yeah. 5 and 2 and 4. Thank you. 5 and 1 and 4. Sorry. Jovic versus Shurin.
Appellant asked for 5 and 2, Your Honor. Respondent asked for 5, Your Honor.
5 and 2 and 5. Thank you. People versus the state of New York versus Jewel Labs. 7, 3, and 7. Thank you. People versus Angel Garcia. 5 and 1 and 5. Damaris C. versus Juan O. Submitted. 118 Dwayne LLC versus New York State Division of DHCR. Sorry.
Joseph Goldsmith for the appellant requesting 7 and 3. David Rosenholz for the tenant respondent 7, and I'm crossing 7.
You said 7 and 3. I'll give you 6, 2, 6, 2, and 3. Bloom versus Jacobitz.
Stephen Hill for that, for the appellant. I request 3 and 3, Your Honor.
Michael Tawil, you'll hear from your Michael Tawil for the defendant, Dediad, 4 minutes.
Is there some confusion? Are you a respondent?
I'm sorry, respondent, Dediad, 4 minutes.
I'll do, for the appellant, you asked for 3 and 3. Is that right?
That's correct, Your Honor.
I'll do for the respondent, first respondent, 3 minutes. For Arch, I believe it was, I'm sorry. 4 and 4. So it's 3 and 3, 3, 4, and 4. Thank you. Star Indemnity versus Zurich American. Uh, 5 and 2, 5 and 2 and 5. People versus Andrew Blake. Six, 2, and 6. RTW Retail Wins versus Colucci and Umans. I'll figure it out. We've read the briefs. We've read the record. We understand. I understand. I think we all do. I heard what you asked for. You are the appellant, and six and 2, 3, 3, and 3. Thank you. People versus Donnell Brown. Submitted. People versus Marquise Spencer. Submitted. Doe versus Bloomberg. Submitted. ISA Realty Group against EBM Development. Submitted. First case for argument is People versus Ryan Conyers. You may begin.
Good afternoon, Your Honors. Brian First from the Center for Appellate Litigation for Mr. Ryan Conyers. I'm going to begin with the SORA certification point before returning to the repugnant indictment point.
Okay.
The people concede that Mr. Conyers has not committed a registrable sex offense, yet nevertheless insist that this court should force him to proceed with an illegal SORA registration because Mr. Conyers, quote, deserves to be on the registry. Now,
Well, counsel, let's assume that we agree that it's not an enumerated offense for SORA purposes. Why don't you focus on the repugnancy issue?
Yes, Your Honor. So the grand jury here, as Your Honors are aware, indicted indicted Mr. Conyers of attempted second-degree burglary as a sexually motivated felony, but refused to indict him for attempted burglary in the second degree, a lesser-included offense.
First of all, did you preserve this argument?
Your Honor, this argument was preserved by counsel's omnibus motion. I acknowledge that counsel didn't make the specific repugnancy objection. However, in these circumstances, I believe that requiring that level of specificity is unreasonable where counsel is on a completely blind record. So I think that what counsel did object to, the multitude of errors in the several different provisions of the CPL that other courts have found to be violated by repugnant indictments, I think is sufficient in this case.
You speak about other courts, so let me ask you, do you have a case, any appellate case, that has determined that the repugnancy argument applies to grand juries as opposed to juries?
No, Your Honor. This is an issue of first impression in this court, and it's an issue that has split the trial courts. Of the cases that I was able to locate on the issue, the majority of the trial courts found that repugnancy does apply to grand jury indictments, and I don't believe the prosecution found any additional cases, including Judge Weber during her time as a Supreme Court justice found that the repugnancy doctrine should apply to grand jury indictments.
Well, what about the fact that jurors are instructed that they may indict if the standards of proof have been met, whereas juries have to find the indictment? I mean, if there is, they have to, find it if the facts allow. This is a little different for a grand jury, isn't it? Don't they have that discretion because of the wording?
Yes, Your Honor, there is that difference in the instructions, but if you look at the cases, the 3 Court of Appeals cases that have addressed the repugnancy issue, that as a basis for distinguishing grand juries from juries as far as the repugnancy doctrine goes is entirely unsupportable. The people's theory rests entirely on this, based on what Your Honor just said, that there's a presumption that when a trial jury finds an inconsistent verdict, that there's a presumption that that is based on an insufficient proof. But that is completely unsupported by the 3 cases that address the repugnancy doctrine.
Let me just ask this question. In the cases of the grand jury, the consequences are a little bit different than the petit jury, right? In the grand jury instance, if in fact there was something repugnant, those charges may be represented with leave of court, whereas we're facing something different with the jury, the petit jury.
Yes, Your Honor. Yeah, I believe in the grand jury that it could be granted leave to be represented, and that could be how this court finds here is that is the appropriate remedy, is to send it back to the grand jury to reconsider the charge with dismissal of the repugnant count, which never went forward. But just to go back to...
I want to go back to the preservation argument, because you just indicated that the indictment and the grand jury proceeding was defective. So that's general. Can you point me to some authority where that would be enough to preserve your argument?
Your Honor, I think it's not, I don't have an authority that says specifically that that is okay, but I think just acknowledging what the position defense counsel is in here with a completely blind record, I don't see how defense counsel is supposed to make that specific objection. But the cases that you see in Cummings, Seifert, and Graham, these are all trial-level cases. I just point out that the court in each of those cases reached this issue on a specific objection. This is quite a glaring error that I think any court, if they were reading carefully the grand jury proceedings, would notice this error. I see my time is up. Unless Your Honors have additional questions, I'll save it for rebuttal.
Thank you.
Good afternoon, and may it please the court, Stephen Kress on behalf of the people. I will start on the repugnancy issue, which is unpreserved. Defense counsel could have raised this in his omnibus motion. He cited 17 other cases that point to various defects that could occur in a grand jury proceeding and asked the court to review.
Well, how would they specifically be able to do that? Presumably, this grand jury indictment occurred prior to the change in the discovery laws, right? So they wouldn't have had the ability to review the grand jury minutes themselves until a much later time in the trial process. So what can they say other than just be general without just throwing everything up against the wall and seeing what sticks?
So I will say two things, Your Honor. The first is, I think that's what he did in this case. He threw out a bunch of potential errors to look for, and he did not include this one, even though there were cases at the time saying that, applying the repugnancy doctrine in the context of grand jury proceedings. So he could have added an 18th case and said, hey, I want you to check for this as well. But even putting that aside, this issue came up at trial. And when he learned about it at trial, he then could have objected. And I'll direct the court to People v. Green, which is a case we cite in our brief, where something very similar happened. At that point, during trial in that case, the defendant learned about inconsistent theories charged in the grand jury. And what this court said was that having learned that, it was incumbent upon defendant to object at that point. And I think the same thing could be said here. He could have objected when he found out at trial that the grand jury had declined to indict on the attempted second-degree burglary charge. Now, defendant has argued that, well, I didn't have to at that point because my motion had already been decided. Well, it was the same case in Green, and also point out that People v. Finch, which is a case they rely on, just says that if you've made an argument and it's been rejected, you don't have to repeat it again to preserve the issue. But this argument had never been made before, so Finch really doesn't apply. But turning to the merits of the issue, I think the reason why convictions are vacated in the repugnant verdict context, they just do not apply in the grand jury context. I think primarily because, as Justice Renwick pointed out, grand juries have the power not to indict even if there is sufficient evidence. And that's actually a critical function of, or a critical component of the grand jury function. And I'll also point out that insufficient evidence in the grand jury, even if you were to assume that a no bill reflects such a finding, that is not a bar to a conviction. CPL 21030 subsection 6 says that there is no appeal from the denial of a motion to inspect the grand jury minutes or to dismiss an indictment as being defective, as long as there is then sufficient proof at trial. And so, even if there's an error in denying the motion, I think the law is okay with that, even if eventually the defendant is convicted on sufficient proof.
Do you want to speak to the issue of the sex offender requirements?
Yes, Your Honor, sure. So we agree that under Simmons, sexually motivated felonies do not qualify as registrable offenses, but I think the defendant in this case, it's not just that he didn't preserve that argument, he actually waived the argument. At the time of sentencing, there were cases, including a case from New York County, saying that sexually motivated felonies didn't qualify as registrable offenses. And defense counsel specifically declined to make that argument. The prosecutor had submitted case law to both the court and to defense counsel advocating the opposite position, and defense counsel declined to contest that.
But if the statute doesn't permit this conviction to be a basis for SORA registration, what does it matter? Why? I'm not even trying to understand why it matters whether he waived it or raised it or not.
I mean, if he waived, he can waive a claim. That's exactly,
But the claim is that, if the claim is that the court has no authority to do this, then whether he waives it or not doesn't give the court authority to do it.
Well, Your Honor, so the Court of Appeals has actually said that this particular allegation does not qualify for the illegal sentence exception, even to the preservation requirement. So certainly, it's not a component of the sentence. So even if it is unlawful, you can still waive that allegation. You can still waive that defect. And if there are no further questions, we'd ask that the judgment be affirmed.
Just briefly on the waiver point, Your Honors, that this court can reach this in the interest of justice. On the SOAR certification, the Second Department just recently reached this issue in the interest of justice in Boyand, a case with immeasurably worse facts. And so, but with to waiver, this isn't waiver in any way that this court knows waiver. It's the people cite Juergens for the proposition that this is waived, but there's nothing to suggest that this is an expressed, knowing, and intelligent waiver by Mr. Conyers. This is a two-sentence comment by defense counsel. The court isn't involved in the colloquy. Mr. Conyers is not involved in the colloquy. Nothing is explained to Mr. Conyers. Nothing is asked of Mr. Conyers. This is after trial where he has absolutely nothing to gain by waiving this. It's just a mutual mistake of law by the court, prosecutor, and defense counsel. So Mr. Conyers, the only lay person in the group who has serious mental health problems, cannot be expected to, it can in no way be said to have knowingly waived this claim, certainly not waived the claim of this court to hear this in the interest of justice. But turning back to the repugnancy issue, I just want to point out that the people's argument rests on this theory that when a trial jury returns an inconsistent indictment, there's supposedly a presumption that it was based on an absence of proof. This is completely inconsistent with every single case that the Court of Appeals has addressed the repugnancy doctrine. Every single case has repeatedly found that we don't do that, that the repugnancy doctrine was crafted with respect for the jury's ability to exercise mercy. That's what the court says in Tucker.
But you're talking about jury nullification, but with jury nullification aside, when you're looking at the facts, what the law is that the court is required to give a jury is very different than what the law is that the district attorney is giving the grand jury.
Yes, Your Honor, but
so that if they're following the law that they're given, one has a choice and one is supposed to only rely on the facts before them to reach the conclusion based on the law.
Your Honor, I just think that if you follow the language of these three opinions that address the repugnancy doctrine of the Court of Appeals, using the supposed mercy function of the grand jury as a basis to differentiate trial juries and grand juries is completely unsupportable. In Tucker, the court that announced it, the court said that it was choosing the elements test specifically to avoid undermining, quote, the possibility that the jury has not acted irrationally but has extended mercy and accepted power of the jury. The court reaffirmed that reasoning in Muhammad and then again in Dali. In Dali, the court found when crafting the appropriate remedy of a repugnant verdict, that the proper remedy was to send it back for retrial on the count of conviction. And that was because it was impossible to know if the jury had based its decision on an absence of proof or on mercy. So no presumption whatsoever that it's based on a presumption of proof. That's core to the repugnancy doctrine. So it just cannot serve as a basis to distinguish the two.
Thank you.
Thank you very much.
Thank you both. Golub versus Alchek.
May it please the court, Leslie Corwin on behalf of the appellant Ira Alchek. The trial court's order, which determined that respondent acquired full title to the premises, was erroneous and must be reversed.
May I ask you then, this is a case where questions of adverse possession are raised, correct? So I want to know, what evidence do you put forth in the record to rebut the adverse possession claims that the plaintiff has had this property for 20 years, I think since 1992 to 2012, and they've done things openly, put on a wooden deck, they've put windows, a door, they've publicized that they need a renter, they've had the leases that have been in their names only, they've paid taxes. What evidence do you have to rebut the evidence that they've put forth?
Good question, Justice Kennedy, but I don't have to.
I'm not Justice Kennedy.
I'm
That's
sorry,
Justice
I'm sorry.
Kennedy, I'm Justice Renwick.
I'm sorry, sorry.
It's okay.
There's nothing that I have to put in the record to rebut that, because there is case law, and that's the Russo case, which says that where one tenant, one co-tenant is in possession and does all of those things, it is for the benefit, there is a presumption under New York law that it is for the benefit of the other co-tenant.
Does that ever expire? Is there a time frame for which that point is considered?
No, because it went on for over a 20-year period. It went on almost for a 30-year period now. And the presumption is that they were co-tenants. They had to show that they had done something to oust, to expel the other co-tenant, who, by the way, it is conceded in this record, and it's what makes this case sui generis, and I do not believe there is another case in New York that has this fact pattern, where you have both tenants conceding here that neither of them knew that the other had were co-tenants until 2000, from 1992 until 2018, when the respondent in this matter had his attorney and a woman who was his cousin and had his power of attorney reach out and say, by the way, we understand that you have a half interest in these premises. So anything that was done up until that point in time, Justice Pittsburgh, in answer to your question, was for the benefit of the co-tenant unless they can prove, and that's where this is key, that they did something to oust the other tenant. And Justice
So
Frederick,
the leases in their name only, the leases without any reference to anybody else, would not be sufficient as well?
that is correct. And in
All the
fact,
other overt acts, none of that would be sufficient?
no. And in fact, Your Honor, and I'm glad you're on this panel, because the case that we have cited is a case that you decided when you were on the Supreme Court in Bronx County.
So it doesn't really count?
Called Blanchard v. Blanchard. And in that case, you said, and if I may quote, in this case, defendant must show that it ousted the plaintiff from the property in question. Generally, ouster requires a written or oral communication of the intent to possess adversely against his or fellow co-tenant. I tell this panel, go through this record. There is nothing in this record which ever shows that that was done. In fact, it's the antithesis. Why is it the antithesis? Because what makes this case unique is that you have both, and it's in the joint statement of facts, you have both tenants here conceding.
So, counsel, what do you think other than not knowing that you existed, correct? That the person who has the administrator's deed since 1992, and I disagree with you, I think the Court of Appeal says absent an ouster after 20 years and showing open and overt acts which repudiate the non-possessory's owner's intent or right, then you get it by adverse possession. I think that's what the Court of Appeal said. So here we have a deed in 1992, 20 years, right, of open and notorious ownership, evidencing this owner's belief that they are the only person who owns the property.
But it's not open and notorious.
What's not open and notorious? They're renting it, they're making edits, they got a mortgage, they got a ton, what else is there? What else do you think they need?
Because they have to do more than that. They have to show more than that. We had no knowledge of doing this.
No, what more, when you just say in general, more than that, they acted absolutely with every single way.
That doesn't do it, because everything that they've done, it's the same question that was just previously asked. Everything that was done, there is a presumption under New York law, as a matter of law, that was done for the benefit of the co-tenant.
Except that presumption doesn't hold after a certain period of time of open and notorious ownership, showing the intent not to exclude the alleged non-possessory tenant. That's what the cases say.
Okay,
Mr.
Kennedy
Corwin
has a question.
I have another question for you. So now this is Justice Kennedy. So you talk about Blanchard, but now with respect to the settlement, the purported settlement agreements, Isn't it a fact that the plaintiff had always maintained that they were the sole owner? And differently, in Blanchard, there was an offer to purchase the wife's share, so that suggested that perhaps the husband didn't intend for the occupancy to be hostile to the co-tenancy.
No, this case is even stronger than Blanchard, because in Blanchard, at least they were aware of the premises. In this case, we are not aware. And you understand, Mr. Alchek is an accountant. He represents the interests of a trust. He has a fiduciary duty to that trust. He gets contacted by a lawyer, and then is ultimately presented with a settlement agreement, which acknowledges the fact
And that all happens after the 20 years, and I'll let you add more on rebuttal.
Thank you.
May it please Your Honors, John Brickman, McLaughlin, and Stern for the respondent. If I may, Justice Kennedy, continue the Blanchard theme. When Justice Renwick decided Blanchard in 2007, the law was unsettled as to what the impact was of an owner's offer to compromise. But in 2016, the Second Department settled that issue, if indeed it hadn't been settled by other cases at the appellate level earlier, in the Midgley case, cited, I believe, in both sides' briefs, certainly in ours. And what the appellate division said in Midgley was, once adverse possession had come into effect, the owner was free to do anything he wanted in order to preserve his title and avoid challenges in litigation. So whatever Mr. Globe and his lawyer and his cousin did after the 20-year period by way of compromise simply means nothing.
Well, your adversary seems to point to the fact that there was no attempt to oust or no ouster for co-tenants. How do you respond to that?
Yeah, ouster has been misused, respectfully, by the appellant in this case. The point of ouster is 541 of the RPAPL says there is a presumption that co-tenants hold for each other's benefit for 10 years unless the co-tenant in possession before the expiry of the 10 years ousts the absent owner. If the co-tenant in possession ousts the absent owner before the expiration of 10 years, then the 10-year period of, I'll call it exclusivity or protection under 541 goes away, and the 10-year traditional adverse possession period begins to run. But if there's no ouster, all that means is that everything remains status quo until the expiration of the first 10 years, and then the usual rules regarding adverse possession.
So I think you and I agree that if you hold open and notoriously for 20 years, you satisfy both the 10-year period at which the presumption is true, plus the additional 10-year period for adverse possession, correct?
Correct.
So if you get the deed in 1992 and you hold open and notorious till 2012, you've satisfied that 10%, that 10-year presumptive period plus the additional 10-year adverse possession period. Is that what are we in agreement with that?
Yes.
Okay.
And indeed, throughout the 20-year period, to address another of Mr. Corwin's arguments, throughout the 10-year period, the respondent does much more than pay the taxes. He does significant and major work on the building, not just at the beginning, but throughout. The record includes his tax returns in 2005. This is on page, from memory, 340-something of the record, but I'm sure the court can look at it later. It's in our, well, it's not in a brief, but...
Yes, we have it.
But he puts $173,000 in capital improvements in. That appears for the first time in the appropriate schedule to his personal tax return.
Of course, someone else wouldn't be able to see that. I mean, they could see the door, they could see the windows. You can't really see the deck if you're, if we're thinking
You
about
can't
it in
see
that
the
way.
173,000, but
Exactly.
173,000 in capital work has to be reflected in reality.
Was there a mortgage put on the property?
Yeah, he puts a mortgage
And was the
on.
mortgage recorded?
Yes, the mortgage is recorded, and moreover, the mortgage contains a covenant by Mr. Galob that he is the sole owner of the property. And presumably, the bank has a title company. The record doesn't include this, but as a matter of ordinary course, the bank would have a title company check out and affirm Mr. Galob's title. And not only does the mortgage go on, in 1998, when he pays off the construction loan, the mortgage is satisfied.
Counsel, when your client went to surrogate's court in 1992, did he have any duty of due diligence to find out whether there were other heirs? And if so, how did he satisfy that duty?
Well, I think the testimony of Harold Kozubsky is more than enough to satisfy it. Harold Kozubsky is a neighbor. He's a friend of the family for 30-odd years. He's a lawyer. And he testifies squarely, as he says in a separate heirship affidavit, that Yale Galob, the...
So we know that he testifies.
I'm sorry, I can't hear
I said we know that he testifies, but we also know that later, after, that's how this case has come to us, is that someone wants to buy the property. And they say, who's this Yale person, or whoever he is? They say, oh, he's dead. They say, do you have a death certificate?
No, I don't think that's how it happened, Your Honor.
No one asked for a death certificate?
The title company asked for a death certificate, and then the title company or the buyer's lawyer, I believe...
In other words, my point is, they asked for a death certificate, and they had to come up with one, where that wasn't done earlier in 1992. It was just the testimony of this friend of the family. And while the court didn't ask for anybody to produce a death certificate in 1992, when the friend of the family testified, it's still surprising that the court didn't ask for this, but they didn't ask, so it's not there. But, you seem to be suggesting that that was plenty. Maybe a death certificate really would have been the final point, the easiest thing to determine whether somebody was dead or alive.
I can't challenge that, Judge. I mean, hindsight is 20/20. But I remind the court...
Hindsight, I mean, you're basically saying the same thing with regard to the mortgage. They put all of this money in. Yes, you can't see the mortgage. You can't see that. But you can see when a mortgage has been filed. That you can see. That we would expect, right?
And you can see when the mortgage is satisfied.
And when it's satisfied, exactly. But the same thing goes for the death certificate. So, but I mean, the reason this is not an issue really is because, well, the judge didn't order it.
Well, and not only did the judge not order it, but in the middle of the hearing, and it was a circuits court attorney referee, to be precise, not a judge. In the middle of the hearing, she stopped it. She said, and this is at page 72, I believe, of the record, again, in our brief, she said, okay, in effect, that's it, I've heard enough.
Thank you.
Thank you, Your Honors.
I want to stay exactly where we are. There was no legitimate investigation ever done here, and I respectfully submit to this...
Yes, but what is the burden on this individual, Mr. Golub, I guess?
No,
I'm sorry, yes. What was the burden on him after the judge didn't ask for anything else? The judge was in control of the determination.
Pardon me, but if you go through the record and you look at the record with respect to the surrogate court proceedings, which I think are at 66, they started the record in 66 and go through to 94. And I ask you to look at it, because this is how this whole started, and it's not right. There was no legitimate investigation. And in fact, in what they submitted to the surrogates court, where he tried to get, when he got his preliminary letters, he doesn't even list the property as an asset. He had no knowledge that it was even there. They go.
There
on
was
the
a death,
they
excuse
go on
me,
the
sir, there was a death announcement that was placed in the newspaper.
Question is over here.
Was that sufficient?
No, it's not sufficient. And I really, because it all starts here, in order for any of this, for there to be adverse possession, there has to have been an intent that this respondent took over these premises knowing that there was somebody adverse to him with respect to it. That didn't happen here, and that's what makes this case unique. They go out, they do an investigation, they go on the basis of somebody who claims that he thought that Yale died, but they never did that. Understand, we had the internet in those days. They could have done a search. They could have done an air search. They do nothing. They put in the testimony of an attorney. And then what happens in 2018?
But it was based on, excuse me, but based on that, the court attorney, referee, and the surrogate issued issued a ruling that he was the sole owner. So why would they have to go behind that if that was satisfactory to the court?
First of all, I think on the basis of doing that, they deceived the court, and that's where it stopped. I think the court below should have at least held a hearing as to whether there was a proper investigation, and this is what the law says, and if there was an investigation, wasn't it reasonable? I submit to this panel, if you go through the record here, what was done here as an investigation doesn't even close to becoming reasonable under New York statute.
Thank you.
And the last thing I will just say, if I can, look at the Russo case, because this has come up. The fact where we all started out, all the things that they did over the years mean nothing because they were tenants in common. They had the
Thank you,
presumption
counsel.
of showing that there was an ouster. There was no ousting.
Thank you. Thank you both. Sakis versus 240 East 46th Street.
Good afternoon, Your Honors. Seth Weinberg with Mara
afternoon.
Lilling, the party for the defendant's appellants. And regardless of the theory plaintiff would use for this case, there's no liability against an employer when an employee does something really as awful as this. There's just no way to justify or in any way condone what happened with the employee in this case. And to focus on this idea of detrimental reliance for a moment, the policy was designed to keep people who did not work in the building, strangers to the building, from making it upstairs. And in this case, the plaintiff was not injured by a stranger to the building.
That was the policy, but there was a policy also that said doormen weren't supposed to go up to the building to deliver any packages. And some of the people who testified said, no, they absolutely were not supposed to go up. The man himself, who perpetrated this assault, said, no, that wasn't the policy. You could go upstairs. So, as far as, yes, they had a rule that said the delivery people weren't supposed to go upstairs, but that wasn't the only rule that they had in the building to ensure the safety of the tenants. So my question really is, isn't there, under these circumstances, with these two differing opinions, isn't there possibility that a jury could find under an assumed duty theory that it was foreseeable that when you put out this kind of rule, the tenants might rely on it and, put their guard down, and ultimately this happens?
We would submit no for two reasons. And first and foremost, my understanding of plaintiff's argument is they're relying on the policy with regard to food delivery. That's the policy they claim they detrimentally relied upon. That's what plaintiff said she was relying upon when she left the door unlocked. So she's not
She said-
relying on
I
that.
think she also said that she was confident that no one would come up. They wouldn't send someone up.
Correct. So she was relying that no one could get up there. But even if there was a policy that no one could get up there, I think we go beyond that to, at some point, an employer has to be able to rely on its employees to do what's the scope of their employment.
Well, that's true, but I'm asking you to focus on the other thing, because there are two things here going
Well, but I
on.
think they're married, Your Honor.
Yes, true, with regard to a stranger coming into the building. But with regard to what happened here, no stranger, the actual doorman, I'm saying, isn't there a valid, duty here that they had? Or couldn't we see in this case that the jury could say there was an assumed duty based on the fact that she's saying, the doorman himself is saying, yes, there was a policy that I could go up and deliver. I could go up to the apartment for whatever the reason was to deliver things.
I don't believe so, because even if the policy was to go up and deliver things, there's no policy to open someone's unanswered door.
Exactly. And so she was under the belief that that would never happen because the building was safe and they would call up and everything. So she left her door open.
Correct.
Pursuant to the policy.
And that's why, to the extent that such a policy is in place,
Or their practice, or what they led people to believe.
I don't know that I'll qualify it that way, but let's assume it is. I think this would be, to my knowledge, the first case in which a sexual assault is found foreseeable. The Court of Appeals has never held that, especially in the context of this case. I think it goes back to, there has to be more than some general awareness that because you have a policy, something could go wrong. I think the cases where something could go wrong and did go wrong, the policy was in place.
But let me put this fine point on it. It's not that the sexual assault occurred, it's that she relied to her detriment on your policy to do something that she would not have otherwise done. And that reliance caused her to do something that was a proximate cause. Maybe not the only proximate cause, and maybe you'll argue correctly at trial that the intervening sexual assault was the proximate event. But isn't it true that her argument is that had that policy not been in place, I would not have unlocked my door. He could not have gotten in. And so that is a proximate cause, one of maybe many or a few proximate causes of why she was assaulted.
I don't believe so, and I go back to the context of this case when we're talking about foreseeability. This is a plaintiff who, when summary judgment came around, refused to oppose negligent hiring, retention, and supervision, and that's important because an element of that claim is
I
it's
agree.
foreseeable that this thing would happen.
No problem, but that's not her claim. Her claim is, I wouldn't have unlocked my door except for this policy, and he couldn't have gotten in.
I think that, and I see my lights on, may I answer the question?
Yes.
I would say that goes to duty, and even if the court got that far,
Assumed
there's still
duty.
the next question
The
of proximate
assumed duty.
cause.
Isn't that the assumed duty that they took on?
I don't.
That was exactly my point. That was exactly my point.
Well, we wouldn't call it that, but I would say even if the court found that, there's still the next step of what's the proximate cause.
Okay.
And we go from...
Counsel, I also have another question for you, because how do you address the fact that the plaintiff testified that she felt safe in the building because you had 24-hour doorman service and that there would be no one to come to the apartment without her express consent? That was another reason for her keeping the door open.
I'm going to let you answer that question or rebuttal.
Thank you, Your Honor.
Thanks.
Good afternoon. May it please the court. My name is Bruce Ressler, and I represent Kate Sakis, who is the respondent.
So let me ask you about proximate cause, because I think that is the real issue here. How do you get around the fact that the lack of proximate cause, that the proximate cause of this woman's injury was the assault, an intentional act, not the plaintiff's negligence, but an intentional assault?
The fact that she felt that she was safe in her building behind the door of her apartment because she had a 24-hour doorman, and, excuse me, I forgot. She had a 24-hour doorman, and she felt safe behind that door because no one could come up without her consent. No one could deliver food into her apartment without her knowing about it. And,
Does it matter that in this instance, the assault wasn't necessarily wasn't perpetrated by a delivery person? It was perpetrated by an employee of the building. And this policy seems to be in place to protect about outsiders, so to speak, delivery people coming up without being announced. They have to be called by the doorman. But this particular doorman did something totally out of character of his job, out of whatever he was trained to do, and went upstairs and committed a sexual assault. How is that not an intervening criminal act that would break the causation?
Very simple, Your Honor. You have to review the evidence in this case. Mr. Gosine, the supervisor and the superintendent of the buildings, who is the manager of the staff, including the perpetrator in this case, said that there was a policy in this building where no doorman could even make a delivery to an apartment. And I asked him that question at his deposition, and he testified to it. And then when I questioned, after getting that admission from Mr. Gosine, I then questioned Mr. Vega. And I said, well, is this a policy here where you can't come up? He goes, oh, no. We used to make deliveries all the time. So this is not a rogue activity. This is a regular happening in that building.
At least there's a question of fact as to that issue.
I'm sorry.
I said at least there's a question of fact based on your question. I don't know that that's for the jury to decide, I guess.
Of course.
You got two different responses to your question.
I agree. I agree. There's a question of fact here, and that's why this summary judgment motion was appropriately denied by the court below. And there is something also to keep in mind here, that when you have to have, obviously you know this, but you have to have, excuse me, you have to have prima facie entitlement.
Lunch must have been very good.
No, it was raining, so I stuck my tie in, and I forgot to take it out. However, there's a prima facie entitlement to summary judgment, and in this situation, the motion by the defendant below failed to make out prima facie entitlement to summary judgment. Therefore, I think that this motion should have been denied, as the court below said, because they didn't deal with the issues that actually upon which this case is based. This is not a negligent hiring case, as the court is well aware. This is a detrimental reliance case. And they keep trying to change the subject, but if you look at every case that they have provided in their papers, every case is distinguishable from our case because none of those cases have detrimental reliance as the gravamen of the claim. And it is also, I think, quite important to remember that besides there is the scope of employment. They cite the UPS case, which I believe is Taylor versus UPS. In that situation, they say, well, sexual assault is, could never be within the scope of employment. You do not have to foresee the harm. Remember the Bell case, where the little girl was on a school trip. She gets left, unbelievably, she gets left by the teachers, and she walks home, and while she's walking home, she was sexually assaulted. So this argument that some criminal act such as rape, which is the sexual assault in this case, we don't have to see the particular harm. It just has to be foreseeable, as Mr. Gosine testified, why he wouldn't let the doorman up to the apartments. You never know. Anything could happen. They could steal something. You don't have to foresee that it would be a sexual assault on that day for this lady, but it is foreseeable. Thank you very much.
So with the court's permission,
Counsel, I want you to start with Justice Kennedy, a response to the question she asked you.
I apologize, Your Honor, if I could just ask you to re-ask it again, because so much has happened since.
No problem. My question was, how do you deal with the fact that the plaintiff testified that she felt safe in the building because of the 24-hour doorman, and that anyone would be prohibited from coming up to her apartment without the express consent, which was another reason why she left the door open?
I think it all sort of bleeds together with foreseeability. And in this case, at the end of the day, we provided a 24-hour doorman who did something he was clearly not supposed to do. And in the argument we just heard a few moments ago, plaintiff's trying to transform that into within the scope of employment, and everything is foreseeable because Mr. Gosign tested, you never know what's going to happen. And to that, I would point this court to the Pink case, where the Youth Hockey League.
So, counsel, isn't that really like the quintessential jury question? And tell the jury, the question is this foreseeable in this circumstance? And maybe they'll say no. And the same thing with proximate cause. You can argue to a jury that there's an intervening proximate cause, but isn't there just enough here to at least say the assumed duty that you took on caused her to put herself in a worse position, and that was a proximate cause of her injury? Maybe not the only one, but at least enough to go to a jury?
Again, Your Honor, we would submit that the acts of this case, the facts of this case were so unforeseeable that just as a matter of law, that can't be. And since I'm going to say unforeseeable over and over again, if the court has no other questions, we'll rest on our brief.
Thank you very much.
Your Honor.
Thank you both. Gentile versus Wegman. You may begin.
May it please the court, good afternoon, Your Honors. Heath Olnowich for the plaintiff's appellants. Just want to start off with a few quick facts about this case.
Well, we know the facts, so get right to the point. That would be better.
Surely, Justice Renwick.
I'll ask you, is there bad faith on the doctor's part where there's some basis for the doctor to believe that the child was malnourished?
No, there's not, Your Honor.
Why not?
In the record, there are only three things that Dr. Wegman claimed, or her lawyers claimed, formed a reasonable basis for the claim of malnourishment. One is that the child presented with a stomach ache. The other is that the child is small in stature. And the third element was that the child was on a special diet at school.
But she didn't wait for the blood. I think she took bloods, and she didn't wait for the bloods. And she waited 2 weeks, and she found out they didn't go to a doctor. She didn't give them any more time. Is there?
Correct, Your Honor, but that's not all.
Wasn't there also indication or questions about whether or not the child had been vaccinated, and so taking those things together?
Yes, Judge Pittsburgh. And that's the whole basis for this action. The mother dropped off the vaccination paperwork at the doctor's office a couple of days prior to the visit, along with the school paperwork he needed for the physical. When she got there with the child on November 13, 2018, Dr. Wegman first asked her, as soon as she walked into the room, is he
Again, we understand the facts. Is your point that the statutory immunity here is liberally applied, and it's a broad statute that protects doctors in these kinds of situations?
Well, there's a presumption of immunity, Your Honor, but that presumption can be overcome when the reporter, in this case Dr. Wegman, acts with gross negligence or malice or intentional misconduct.
And so do you see that there's malice or gross negligence here, or
Absolutely, Your Honor.
intentional conduct?
Because Dr. Wegman erroneously believed that the child was not vaccinated, and because she recounted to the mother her own experience with her own child almost dying from contracting pertussis from an unvaccinated child, that set the tone for the whole visit. All she has for a claim of malnourishment is a small child with a stomach ache who was on a special diet, all of which the mother explained as far as why that was.
But didn't the doctor also rely on the fact that he recommended that they see a pediatric gastroenterologist, and that a week or two later they had not done that? And although they said they were going to go to a different doctor, they in fact had not yet made an appointment or taken any steps to do that.
Well, that's
Wasn't
not
that an
accurate,
appropriate
Justice Ginsburg.
consideration for the doctor to consider?
I'm sorry, that's not accurate, Justice Gesmer. What Judge Rackhauer said below in the oral argument is that all we knew and all the complaint tells us is that Dr. Wegman did not know about a follow-up appointment. She had somebody at Global call Mrs. Gentile 2 weeks later to find out whether or not they followed up with Dr. Solomon.
And at that point, they hadn't, correct?
They hadn't because at the initial visit, the mother told Dr. Wegman that she was not comfortable using Dr. Solomon because Dr. Solomon had previously misdiagnosed a case of C. diff in the child, and
But
that she wanted to...
when the doctor's office called her, she didn't say, "We've already made another appointment, thank you very much."
That's actually not accurate. When the Global employee called Mrs. Gentile 2 weeks later, and let's forget about the fact for a second that in that 2-week period, Dr. Wegman did absolutely nothing to confirm her suspicions of malnourishment. This child had been at this particular facility 10 times before. Dr. Wegman saw him twice before. There's never any indication in his record of malnourishment.
But it's gross negligence is the standard, isn't it?
It's gross negligence or...
Is this gross negligence?
Or acting with malice or intentional misconduct.
Where's the malice? Where's
Or the intent
malice?
for that
The malice
matter.
here, Your Honor, is that Dr. Wegman was so clouded by her own vision of the fact that this child was not vaccinated, she has a vendetta
But
against children
clouded
that
by
are-
your own vision is not malice or intent, as my colleague suggests.
But she made an intentionally false report of child abuse when the circumstances, a stomach ache, a special diet, and a small child would not have indicated.
Counsel, she's a mandatory reporter, correct?
Yes, she is, Your
And
Honor.
with the facts that she's given, she's going to report that. Where is it that she acted with some kind of harm to specifically harm this mother by reporting what she's mandated to report? Even if it's a mistake, where's the willful misconduct? Where's the gross negligence? Where's the malice, as you put it?
I see my time is up. If I can answer your question.
Go ahead.
The malice is in the fact that Dr. Wegman knew that her report of child abuse was false. All she had was a small child with a stomach ache. When she found out, or when she mistakenly believed that this child was not vaccinated and related it to her own child's experience almost dying because of an unvaccinated child, she had a vendetta against this plaintiff. She also waited a whole 2 weeks, even though, as you point out, Justice Pitt-Burke, that she's a mandated reporter. This mandated reporter didn't report this supposed case of abuse for 2 weeks. And then she only decided it was abuse because they decided to take him to a different doctor than the one that they recommended.
Thank you.
Thank you, Your Honor.
May it please the court, my name is Dan Ratner. I represent Dr. Wegman on the appeal. I think the facts were already outlined. 2 weeks into...
Counsel, I'd like to start with the 2 weeks.
Sure.
And what, if any, allegation did the plaintiff set forth that after the representative contacted them, that they advised the representative, we contacted our own specialists and we have an appointment for a particular date? Was that anywhere in the complaint?
No, and not only wasn't there was a lack of any allegation that an appointment had been scheduled, but there was also somewhat of a misconstruing of the record as outlined just now by opposing counsel. At the time of the initial appointment, there's no allegation here that the parents said to Dr. Wegman, oh, no, I'm not going to see that particular pediatric gastroenterologist. I've had a problem with that person in the past. There's nothing to that effect. So 2 weeks later...
So, counsel, you're saying that's something that was in their head but not expressed to the doctor, at least...
Right, we're
I
here
didn't
to
see it in
decide
the
whether on the
complaint.
four corners of
Right.
this complaint,
Right.
there's any allegation that of real bad faith or gross negligence or intentional misconduct. And none of that is here.
And this child is nonverbal, correct?
That is correct.
So the doctor couldn't ask the child any of the questions about the low weight and the gastro problems,
That's
correct?
correct. But what the doctor could see or hear from the parents was that there was a small child who looked to the doctor malnourished, as you said, nonverbal. So she did the right thing. She said, okay, go see a pediatric gastroenterologist. And it wasn't until after that that she made the report to CPS in good faith. At worst here, there is a misunderstanding, at worst. But the statute protects mandatory reporters in those circumstances.
Or even negligence, but
At worst.
that's protected too.
Fair
It's
enough,
gross
fair enough.
negligence.
The allegation that she should have looked back in the chart or whatever, that's ordinary negligence. Correct, Your Honor.
And what do you say to the allegation about she had a vendetta against them because she thought the child was unvaccinated?
Well, I think it's highly speculative to make that assertion. It doesn't necessarily trump the rest of the evidence that's alleged in the complaint about the baby's appearance, about the referral that was made, but not the appointment that was not kept or not made. It doesn't really it's just speculation against all this other evidence. And a pediatrician is mandated to act on their, if you will, hunch or professional hunch, if you want to call it that. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. May it please the Court. Adeline Medina on behalf of Global Pediatrics. Without repeating too much of what my co-respondent has said, I just want to add that part of the significant portion of the analysis here is what the statute requires, and the statute requires the mandated reporter, in this case a physician, to report even on a suspicion of maltreatment, in this case malnutrition. She's not required to perform her own investigation. She's not required to try to determine whether or not it's accurate. That aspect of the process is left for the Child Protective Services agencies. Once she reports, an investigation ensues, and this is exactly what happened in this case. There was no harm. There was an investigation. The parents' home was visited by Child Protective Services. They went to the school, and they made a conclusion that the physician, in this case, was not involved in that aspect. She's not required to be involved in that aspect. All she's required to do is, if she has a suspicion, as we have discussed, counsel has discussed already, the underweight, which is admitted and conceded in the complaint, the child was described as tiny, on a parent-imposed restricted diet, and brought in with complaints of significant discomfort, stomach discomfort. She has a suspicion, coupled with, 2 weeks later, we have a call to confirm that the child is followed up with a specialist, and the doctor is told, no, he has not seen a specialist. You have this amount of information that is available to Dr. Wegman. She's not required to go further. She's required to have the proper authorities conduct their investigation because that's their role. She doesn't have a part in that aspect. And with respect to the other allegations, I just want to add that there is no harm alleged here as to the infant. The infant, there's no allegation that the infant even learned about the investigation. The infant was never removed from the home. In terms of the parents, there is no duty as to them with respect to the complaint. In fact, the statute, by virtue of what it's intended to do, is to protect the infant, even at the risk of prejudice to the parents. The parents would be the potential party to be investigated. The physician cannot have this conflict of a duty to the patient as well as the parent. The duty is to the patient, not the parent. If the court has no further questions, I will end my brief. Thank you.
Thank you, Your Honors. This focus on the follow-up appointment 2 weeks later seems to me to be a red herring. In the record, it is stated that Mrs. Gentile, when the global employee called her 2 weeks later, she told the employee, we're taking him to our own pediatric GI, Dr. Levy. There's nothing in the record, and the defendants, respondents haven't pointed to anything otherwise that shows that the global employee asked any questions about whether...
There's no showing that they actually had made an appointment with that person, just that they were going to do it, right?
Taking the allegations of the complaint, Justice Gesmer, in the light most favorable to the plaintiff. The implication when Mrs. Gentile tells the global employee we're taking him to Dr. Levy is that an appointment had been made. Whether or not discovery bears that out.
Wait. You represent that person, right?
Yes, Your Honor.
So you asked that person at the time, what did you say? You don't need any discovery, it's your client. So why did you not plead that if that's what happened?
We're talking, though, about the sufficiency of the complaint and whether
I
or not.
agree.
And whether or
So
not
here you are telling us, I don't know what discovery is going to show about what my own client said, and I am saying to you, why would you need discovery for that? Why wouldn't you interview your own client before you brought a complaint?
Well, I think you misunderstood me, Justice Scarpula. I'm not saying that, first of all, I'm not here testifying, obviously. Second of all, I'm not saying that I didn't interview my client. What I'm saying to you is what's in the complaint is that the global employee asked her if she followed up with Dr. Solomon. In response, Mrs. Gentile said, we're not going to go to Dr. Solomon, we're going to our own GI, Dr. Levy.
And at the time she said that, that was 2 weeks after she brought the child in because he was suffering significantly from gastro problems,
Correct. And there's also an allegation in the complaint that that was the soonest they can get an appointment with Dr. Levy was on December 10th. When the stomach ache, there's nothing to suggest that the stomach ache went on for 2 weeks. She brought him in at the time he had a stomach ache, at the same time he was supposed to be going for a physical. Whether or not she was able to make the appointment sooner, the complaint says that she wasn't able to get one until later. And if I could just say one more thing, Your Honors.
Okay.
The statute has a presumption of qualified immunity. It's not absolute. It's not irrefutable.
No one here, I haven't heard anyone say that it wasn't refutable. But I think what the questions have been is, was it gross negligence? Was it intentional? Was it, with those kinds of questions? That's what you have to be able to refute it with.
Based on the allegation that Dr. Wegman had a personal animus towards these people because she believed the child wasn't vaccinated, and because of her own experience with her child almost dying from an unvaccinated child, that is the motivation, that is the malice, that is the intentional misconduct, that is the precipitation.
Overprotection. That might be overprotection or negligence or something, but malice and having a vendetta against the patient because of that?
But it's alleged in the complaint, Your Honors.
Thank you.
There has to be a reasonable good faith basis. You can't just say for every parent that brings a child in with a stomach ache, malnourishment.
Thank you.
Thank you, Your Honors.
Thank you both. Thank you all. Lakia versus Volchonok. May begin.
Good afternoon. May it please the court. I'm Diana Fossbender with ORIC, pro bono counsel for appellant, the mother, Miss Samantha Lakia. We are here today because the trial court abused its discretion in awarding attorney's fees in favor of the father and denying the mother her fees. If the lower court's order stands, the mother will be required to pay the father a total of $40,000 in fees from a motion sequence that the father started to halt a pelvic examination of the couple's then 4-year-old daughter that was directed as part of an ACS investigation into an allegation of sexual abuse against the father.
I have a question.
Sure.
If we were to decide that the court was wrong in denying your client attorney's fees, is there enough in the record for us to award attorney's fees in a specific amount, or would we have to remand it for that purpose?
There's,
This is only a question, not a conclusion, just to be clear.
I understand. No, there's in the record support that she incurred attorney's fees in the amount of $46,000. That was the amount sought before the trial court.
Okay.
Where is that in the record?
Okay,
so you'll find it on rebuttal or something and let us know.
And I believe the attorney's fees were, the invoices were submitted as well.
And what are the factors that you contend support our awarding attorney's fees to her?
So she's the non-moneyed party. She's completing a dental residency, lives off student loans, presently has a negative net worth, and this court already found she could proceed in formal pauperis in this appeal. On the other hand, the father earns over $600,000 per year. So we would submit that the rebuttal presumption is in her favor.
Was there any question as to whether or not she was the prevailing party that is the impetus behind the award of attorney's fees? Or was it kind of like, well, this person delayed, this person delayed, this person brought this action? It was a kind of evening out, so it would be a wash. How is she prevailing?
Well, the basis of the father's motion was to halt the child's pelvic examination. The court initially paused that based on the unsupported notion that the mother had reported the allegation of abuse, which was false. That examination eventually had to go forward. The other basis of relief that the father sought also did not come out in his favor. So, for example, his motion sought 10 and a half hours of makeup time that he claims the child was withheld. This was the evening that the child was at Bellevue. He was only entitled to 3 hours of custody time to begin with. His father sought, the father's motion sought sanctions for statements that the mother allegedly made to Bellevue staff. But the trial court does not have jurisdiction to enter sanctions against a person for statements they make outside the context of litigation. That was that her visit at Bellevue occurred before the litigation commenced. So the relief that he sought drove up the mother's costs and fees. He exacerbated the litigation by raising a host of other irrelevant issues that had nothing to do with that.
Counsel,
Yes.
would it be fair to say that of the issues that of the relief that he sought, the only one that he actually got was attorney's fees?
I would agree with that conclusion. And otherwise, one of the earlier questions about why attorney's fees should be awarded in her favor, he used the proceedings to exacerbate the litigation by raising a host of issues that had nothing to do with the sexual abuse allegations. The father submitted over 50 pages of declarations from his counsel alone, plus a declaration by him. All of those allegations and assertions required a response by the mother and her attorneys. And we would submit that the inequities of this situation are exactly what the fee statute is meant to address.
Counsel, what, if any, evidence is in the record that the mother breached the settlement agreement and also delayed the proceedings?
There's a lot of speculation and supposition, but there is no evidence. I believe the basis of the assertions that she breached the settlement agreement was consenting to the child's vaginal examination without the father's consent. And that was the basis of the court's fee award. But here we're talking about, first of all, the examination had to take place. The court has recognized as much. And the accused consent shouldn't be required in the first place. And beyond that, with respect to the medical records, there seemed to be a lot of confusion about whether the father did or did not have access to those records on his own. But in both instances, her attorneys did provide them, and certainly within the opportunity to cure period that the settlement agreement provides if she had been afforded that opportunity. Thank you.
Thank you.
Good afternoon, and may it please the court. I'm Margaret Donahoe of Donahoe Talbert for the respondent, Alexander Volchenik. I would like to highlight that this was an enforcement proceeding in which the court issued 4 orders before the order for the attorney's fees, all of which granted relief that Dr. Volchenik had sought in his order to show cause.
But some of those were interim relief, which were eventually reversed, correct?
No.
One of them was to pause the holding of the exam, and then ultimately the court directed that it be held, right?
So the relief sought was to pause it until the medical records.
Right, but the ultimate relief he wanted was to prevent it from happening.
No, we never asked for that. If you look at the order to show cause, we never asked for that.
When it was finally, when the order to pause the exam was lifted, did your client oppose that?
No. There
was
was a
in favor
conference
of it?
with the court about, which the ACS liaison agreed with, about doing the examination at the pediatrician's office. It was the second genital examination of the child. It was going to use a speculum. In conference, it was agreed it would be done by the pediatrician. The mom then withheld permission for the attorney for the child to speak to the pediatrician's office and set it up. She did that for almost a week.
Where is that in the record?
I can give you the citation. It's in my brief as well. I will explain that ultimately, when the attorney for the child was able to speak to the pediatrician's office declined to do the examination. Dr. Volchnik immediately consented to the examination taking place at Bellevue. There was then a delay by the hospital and ACS in scheduling it to their own scheduling needs. But one of the, in terms of the question you asked Appellate's counsel about delay, the mother twice withheld the medical records from Justice O'Neill Levy that showed benign results for abuse. She twice withheld consent for the child's attorney to make necessary inquiries that Justice O'Neill Levy had asked for so that we could be trying to resolve issues in conference, which was the court's preferred method of addressing the relief that was sought.
Where is that in the record?
I'm sorry, I'm looking for the pages in my brief so I can give you that reference. And of course, I have the wrong brief in front of me.
While you're looking for that, I have another question.
Yes.
Can you point us to where in the record that it's been established that the mother gave false information to the hospital regarding the existence of the order of protection?
Both the hospital's record and the ACS record reflect that the mother told the hospital when she was there on the 13th that there was an active order of protection in place against Dr. Volchnik. That was not true.
The only evidence of that double hearsay?
I think what the court was reacting.
Can you point me to any non-hearsay evidence supporting that?
Well, the mother never denied that she told them there was an order of protection.
Yes, she did. She said that she had said, as I recall her testimony, was that she was asked, has there been an order of protection between you? And she said, yes. She didn't, her testimony was not that she had said there was one in effect at that time.
So I think when Judge O'Neill Levy was looking at the totality of the circumstances, the relative merits of the positions taken by each party, she was aware that Dr. Lakia said very different things to Judge O'Neill Levy than were in the ACS records and in the hospital records.
But that was based on hearsay of what had happened in the hospital, right? The fact that Judge O'Neill Levy found it doesn't mean that it was based on non-hearsay.
She relied upon the ACS records and the hospital records on the legal fee application by consent without a hearing. So you're right that there was no hearing on the legal fee application where she addressed the totality of the circumstances. That was by consent.
I have a question about I'm just going to ask to hold. Have you found that information? If not, I'm just going to ask to pause the questions so you can find that, so that if there's any contradiction, it can be addressed in rebuttal.
It is in page, the references are page 34 and following of my brief to the mother's delays in the record, and they appear again, all of those references on page 58 of my brief, the record citations to the delays caused by the mother.
You said it's page 34 of your brief. What are the record citations?
The record citations related withholding the medical records, pages 35, 93, 122 to 23, 126, 174 to 209, 229 to 231, 257 to 280, 568, 616, and then additional references to delays caused by the mother at pages 180, 203, 530 to 536, 565 to 566, And then further, delay when asked for permission to speak to the school, which the mother also withheld from the attorney for the child, pages 564 to 565.
Can I ask one?
Okay, yes.
My question in relation to the delays that you're mentioning, were they subject to the cure period at all, which would require written notice, or are they something separate from that?
It's in the record that we did not serve a notice of default because of the nature of the situation. We went directly to the court because we viewed it as an emergency.
Well, the agreement requires that this written notice be served?
It requires for the fees to be automatic. However, we do have 2 citations in our brief where that is not strictly construed, where violation of the agreement is clear. The biggest violation of the agreement here was that she withheld the child from access when ACS hadn't sought to do that. And one of the orders we achieved from Judge O'Neill Levy, which was sought on this motion, was restoration of my client's access. You can see in my brief, the position Dr. Lakia took with the trial court was suspension of access. Mr. Aronson is quoted in my brief with their request to suspend access, relief the mother had already helped herself to.
Counsel, I'm under the impression that appellant's counsel only asks that the father's access be supervised until the time being that the ACS investigation has run its course. I don't see a request that it be access be terminated, only that it be supervised. So where in the record is that?
On page 22 of my brief, record 180 and 203, Mr. Aronson pressing the court that the access should be suspended.
Any further questions? Thank you.
Thank you very much.
So to begin with the first question, the council's motion below it's at 339 in the record. That includes details about the fees that the mother incurred. In terms of the request for access, it's correct. The appellant's counsel did ask for visitation, if not to be suspended, then to be supervised while the investigation unfolded. And I think the reasons that he presented were very cogent, which was that in addition to needing to see...
And what about the 2 instances of denial of access to ACS? Are those, what is that about?
I'm not actually sure what that's referencing. I don't know when that happened or where along the way, or how that exacerbated the proceeding.
Anything else?
Thank you. We would ask that the court reverse and award the mother her fees. Thank you.
Thank you both.
Yeah.
Jovic versus Shuren.
Good afternoon, Your Honor. Seth Weinberg with Mara Lillian, the party for the defendant appellants. And I'd like to begin with the 3211A1 branch of this motion and return the court's attention to the allegations against Montefiore Medical Center. Particularly, the allegation is Montefiore Medical Center negligently owned Montefiore Nyack. And what the certified certificates of incorporation confirm is Montefiore Medical Center does not own Montefiore Nyack. They are sister subsidiaries of a third corporate entity, the Montefiore Health System.
So Montefiore Medical Center is in the Bronx.
Correct.
Montefiore Health Services is in Westchester.
That's the parent company, that's in Westchester.
And that's the parent company of Montefiore Medical and of Nyack.
Correct, and Nyack is, I believe, either Rockland or Westchester.
Were any of the providers that service the patient from Montefiore Medical?
No.
From the Bronx Hospital?
No, and that shifts to the 3211A7 component and what the chart confirms is that the decedent was admitted to Montefiore-Nyack. She never left Montefiore-Nyack, and all the treaters were at Montefiore-Nyack.
And she wasn't, was she refused service from Montefiore Medical? If that makes a difference, but was she refused medical?
No, what the record seems to indicate is that there was a family question as to whether she should go to the Bronx. There's an unnotarized, we'll call it an affidavit, even though it's not, suggesting that the Montefiore Medical Center gave the bed away that would have been available to another patient, but that's, again, there's no physician-patient relationship at that point, and there's no law to suggest Montefiore Medical Center was under an obligation to hold a bed for this patient.
Was there another hospital that was asked? Was Westchester Medical
Yes.
Center involved in?
Westchester, yes, Westchester was asked. They did not have a bed available, and then they moved to then they moved to Montefiore Medical Center.
And Westchester is not a part of this action?
Westchester's not a part of this action. And with regard to the suggestion in the briefs that discovery should be allowed to discuss the relationship between Nyack and Montefiore, I would direct the court's attention to the Second Department's East Hampton decision, which was ultimately affirmed by the Court of Appeals. And in that case, the court held, we can't allow conclusory allegations in a complaint about piercing the corporate veil to subject corporations to discovery about their internal workings and policies. It defeats the purpose of being incorporated. And when you boil it down, plaintiff's real argument is all these entities have the name Montefiore in them. There must be some sort of relationship there. And I think the Finnerty case out of the Court of Appeals explains that. And in that case, it was Ford USA and Ford UK. And the appellate division held that Ford USA, as the parent and the guardian of the Ford brand, could exert pressure to maintain what Ford UK did. And the Court of Appeals said, well, of course the parent can exert pressure, but that's not enough to create any sort of corporate liability. And here we have two subsidiaries. There's not even a parent corporate relationship. It's a sister subsidiary relationship. So finally, we would submit that once Montefiore Medical Center is dismissed from the case, at that point, our request for renewal should be granted, and the case should be transferred to Rockland County, where all of the care took place and all of the parties reside. And if the court has no other questions, we'll rest on our brief.
Thank you.
Thank you.
May it please the court, Elliot Lewis from Sacco and Filas for the respondent. When plaintiff initially investigated this medical malpractice case, the first information that I obtained regarding the involvement of Montefiore-Nyack Hospital, where the decedent spent her last illness, was that Montefiore-Nyack Hospital was advertised publicly, widely, as being part of the Montefiore health system.
Well, it would be the Montefiore health system, right? It would be part of Montefiore Health Center.
Well, the publicly available...
And that's in Westchester. That's the parent, right?
The publicly available information is that Montefiore Medical Center operated something called the Montefiore Health System, which included not only Montefiore-Nyack Hospital, but hospitals throughout the Bronx and throughout Westchester. And this was a fact.
Publicly available information, are you talking about advertisements or the Department of State?
My initial investigation was mostly on the internet. And
I understand, but before you would file a complaint, I assume you would then look at the Department of State records and find out what the corporate relationship actually was.
we do look at the Department of State records. However, I don't think that they fully explain the relationships between the entities. Apparently, Montefiore Medical Center and then Montefiore-Nyack are technically co-subsidiaries, and then the parent corporation is Montefiore Health System, but it seemed to me that Montefiore Health System may in fact just be an alter ego of Montefiore Medical Center.
And what do you base that on? What allegation do you have that you base that on, other than you feel like it's so?
Well, I can tell you the research that I saw.
Well, let me just start with, what did you plead in the complaint? Let's start.
Oh, yes.
What did you complain about alter ego?
The only language in the complaint, and again, This is an appeal of a denial of a motion to dismiss for failure to state a claim.
Right, so you got to plead at least a minimum to show that there's some reason for us to go forward with a piercing claim.
Well, I can tell you that.
Opposition, right, in support of their motion, counsel for the Montefiore puts in all their certificates of incorporation and an affidavit saying, here's our corporate structure. These are all on file, so they're all competent evidence of the corporate structure. So in opposition, what did you put in to raise an issue of fact with respect to, or at least bolster your complaint with respect to piercing?
In the complaint and in the record at A723, the allegation is made that Montefiore Nyack Hospital and that Montefiore Medical Center stood in such relationship to Montefiore Nyack Hospital.
Again, that's a conclusion. I'm asking you, what fact did you plead to show that?
That they operate the Montefiore health system that included Nyack Hospital.
So you're saying that anytime there's a parent and subsidiaries, that's sufficient to allege a claim for piercing?
Well, again, this is a motion to dismiss for failure to state a claim. And the question is, has plaintiff stated a cognizable claim as a matter of law? And I believe that we have. The law is clear that if we can show that the co-subsidiary completely dominates and controls.
Exactly. So what fact did you plead to show that the one completely dominates the other? Other than saying it's so, what fact did you plead?
I don't think we have to do that. I think if the complaint alleges a cognizable claim, granting the plaintiff, the pleader, the broadest inferences possible from the evidence, given that there is a...
But what evidence is there of that, other than that they all have the same name?
Well, there is evidence that Montefiore Medical Center was involved in transfer of the patient, and there is an affidavit...
Was she ever transferred to the Montefiore Medical Center?
No, that never happened. She died at Nyack.
And that wasn't the only hospital that was contemplated. So
that's not agreed upon by the plaintiff. The plaintiff believes that Montefiore Medical Center was the target hospital where the transfer was to take place. She doesn't agree with...
Okay, but it doesn't matter.
Well, she disputes
doesn't matter. There was Westchester Medical Center was also looked at. Montefiore was looked at. I don't understand how that then meets the requirements.
Well, again, the standard for dismissing a complaint for failure to state a claim sets a very high burden of proof on the move-in. And the question is whether plaintiff has set forth any cognizable claim as a matter of law. And
is part of your claim, did you plead that Montefiore Medical Center rejected this transfer?
Yes.
How did they do that?
The plaintiff's survivor was told that the bed that was available where this technology was available for treatment of her conditions, that bed went to a local Bronx resident and that she couldn't be transferred, and then she died at Nyack Hospital.
Wasn't there also some sort of record made that the MCC would have accepted her? I mean, I think your claim is better with Westchester, who rejected, right? MMC considered it, but then the bed was gone.
My understanding is the transfer to MMC was not completed. They were told, the plaintiff was told that there was no bed available and there was no transfer. She denies that there was consideration of Westchester Medical Center.
So what, okay, I don't want to belabor the point, but I think we're all a little baffled at the fact that there are many, many patients, and sometimes beds go to the person who they get there first, or who may be equally as ill, but that's rhetorical. Thank you very much.
Thank you.
Your Honors, I'd just like to make a few quick points, if I may. An investigation of public available documents would also include the Secretary of State's Certificate of Incorporations, which are on file to be ordered on the website. It's not some secret. It's not necessarily plastered on the website. You fill out a form, you get the order. So if Plaintiff's counsel wanted to investigate the relationship and put what we put in the record, he could have without much difficulty. I think Plaintiff's counsel is also misstating the 3211A7 standard as it applies to this case. What the Court of Appeals has held is once evidence is submitted, the standard shifts from, did plaintiff state a cause of action? Did this plaintiff actually have a cause of action? And the evidence here shows they don't have a cause of action. And the only evidence counsel refers to...
Did the plaintiff put up any evidentiary, did the plaintiff make any evidentiary facts to support a claim for piercing? That's what I'm trying to figure out. Other than saying, I want to pierce, are there any facts that show any of the elements of piercing?
No, there's no allegations or facts on that. And what we have here is, if the court will recall, there was a prior motion made to change venue. So since part of this motion was a motion to renew, we submitted that prior record. In that prior record was an unsworn affidavit, if you'd call it that. It's really a document. It's of no evidentiary value that seems to state what plaintiff says. But when plaintiff opposed this motion, no exhibits were submitted, no reference to the prior exhibits were directed to the court. So really what the trial court did in this case is it went even beyond where plaintiff went. It searched the record, the medical records. It found that a doctor suggested we could do a transfer to MMC and said, at this early stage, I'm not willing to dismiss the claim because there's a question of fact as to why the patient didn't go to MMC. And we would suggest there's no allegation or evidence of a physician-patient relationship, and therefore there can be no malpractice. And really, there's nothing else to do discovery on at that point. And once that claim goes away and the corporate liability claims go away, MMC should be dismissed and the matter should be transferred to Rockland County. So if the court has no other questions, thank you.
Thank you both. People of the State of New York versus Jewel Labs.
Good afternoon, Your Honors. Jonathan Ellis, may it please the Court, Jonathan Ellis, argue on behalf of my client Adam Bowen and his co-defendant James Monsees. The Supreme Court's order should be reversed. We've offered two independent grounds in our brief, but most fundamentally, New York courts lack jurisdiction over Monsees and Bowen. Despite touting access to more than 7 million documents, the state has pointed this court to about 35 to support its claim of jurisdiction over in this case.
The question isn't how many documents show it, but what the documents show. So maybe it would be helpful if you would address why you think that what the documents show isn't sufficient.
Happy to, Your Honor. We think none of those documents meaningfully support or show any connection between New York and Monsees and Bowen, as opposed to JLI in relation to the state's claims. The Supreme Court rightly found that the collection of board presentations and the emails addressing JLI's marketing in New York, among other big picture strategy decisions, were insufficient to show that the board members, like Monsees and Bowen, personally transacted business in New York. The defendant's brief presence in New York surrounding Jewel's 2015 launch are both too distant in time and too unrelated to the claims against them to serve as to form a basis for jurisdiction.
Why is the launch unrelated to the claims of the Attorney General in this case? It seems to me that the claims relate closely to issues about marketing and promotion. So why is the launch unrelated to the claims in this case?
So the standard is arise from or substantially related, Your Honor. And this case, although the case and the claim, state's claims are broadly about JLI's marketing, they're actually about particular false statements and particular conduct. They're laid out at page 95 to 96 of the record in the paragraph 15 of the complaint. There are things like not stating sufficiently clear the nicotine in the product, or marketing to youth, or marketing the product as a smoking cessation device. I think if you look at the record about Monsees and Bowen's attendance at those launch parties, there's no allegation that they engaged in any sort of marketing to youth at those events, that they made any false statements about the product. We think it's similar to Gasarch, the court's decision in Gasarch, where there was obviously the individual defendants had been in New York in seeking investment, but the court said that's not sufficient to make them substantially related to the claims, because
Counsel,
there's no
how do you
allegation
deal
of
with the
tortious conduct.
California's finding that New York has jurisdiction?
We disagree with that finding, Your Honor. We don't think.
Yeah, obviously, but why?
Well, because they didn't engage, that court didn't engage in this court's doctrine. It didn't engage in the record before this court. We can't appeal that at the moment. It's in federal court, so interlocutory appeal is much more limited. But we continue to contest jurisdiction in that case on summary judgment, and we'll continue to do so throughout that case. And we think the record here is just not sufficient. As I was saying, in Gasarch, charge, the court noted that there was no allegation that the defendants had committed any tortious conduct in New York. And so I think when you strip away the minimal contacts personally for Mr. Monsees and Mr. Bowen, what you're left with, what the state is left with, are their titles and the vague and
So these two are not just board members, right? They're the founders of the company. They find the company in San Francisco. They are driving this company, right? They're not just passive board members.
They are the co-founders, Your Honor, but the court has said over and over again the titles are not sufficient. And I agree, you're right, Your Honor, the question is whether the driving force behind the misconduct at issue here. And I don't think, I would urge the court to look carefully at the record. There's only about 500 pages that the state has submitted. And if you look at that record and in light of the specific allegations of misconduct, again.
But in the beginning, I know, starting with around December 2014, there are emails from Monsees indicating that he's going to be in New York City to discuss potential investment. I know it's not simply investment about Jules. The same thing happens on several different dates in 2014 and 2015. Then they talk about the launch party, as has been discussed, and constant email there, separately and with the board. But then separately again, Bowman in June of 2015 talks about the launch party, and in February of 2016, he emails something with an attachment about his thoughts, where he talks about the amount that Jules should spend on national awareness. I mean, those kinds of things are, he says, I think we gave up too easy on getting mainstream press coverage on Jules. That seems very involved in the advertising and the thought process and the direction of which this was going.
So Bowen and Monsees are both engaged with the company. They are on the board, just as the rest of the board members were. They are receiving this information, and they occasionally comment. I think if you look at those emails, many of them you cited contain other members of the board as well.
No, not that one. There are, I deliberately went over the ones, there are many, many, many more that relate to the board. I'm only talking about the ones that relate to Bowen and Monsees.
So I think if you look at those, you will
find them. In the January 2017 email to Monsees, there's another one where he states that New York City users are the focus of branding and marketing in 2017.
There's no question that JLI the company focused on New York and made it a priority for its marketing efforts. But what you won't find, Your Honor, is evidence that they are the driving force, that they are the primary actor. So if you look at things like, take Kruder, for example, where the individual defendant there formed a New York company for New York investment and then directed the funds from New York to Texas. If you look at Calder, which of course is a due process case, but it's the backdrop here, it's the editor and the author of the defamatory article. These are not board members. These are not people who are engaged in getting
Yes, but as my colleague already said, these are not mere board members. They're the people who thought this up.
They are, but I don't think that's sufficient, Your Honor.
That's pretty significant.
I don't think so, Your Honor. I don't think that their status...
It's not sufficient, no. No, it's not. But when you look at the emails that they sent, isn't it important to put that into context, that when we're talking about the board, that's one thing. When we're talking about emails coming from them in particular, we're talking about emails coming from those people who thought up the product. They don't have any more interest. Their emails aren't any more important than other members of the board.
They certainly have interest, Your
Add
Honor,
as a
but they're...
friendly amendment, and they held executive positions in the company. They weren't just board members.
That's true, Your Honor.
The CEO and the CTO.
That was true in Caribou. The CEO, the CFO, the COO were in that case. Those comments from those individuals obviously carried weight, but there wasn't sufficient record in that case or allegations to show the direction and control for the specific misconduct. We think the same is true here, Your Honor.
And I would also like to address on rebuttal the media and PR outreach efforts. We can discuss that on rebuttal.
Thank you, Your Honor.
So, counsel, I'm going to go right in and ask you, what do you think about the argument? Yes, they were involved in the company, but they were not specifically involved in the activities that are the crux of the AG's claim.
So, two responses to that, Your Honor. First, just a response on the facts. I think, let me just point out 4 or 5 different places where they were specifically involved in marketing efforts. During this launch weekend where they personally decided to bring a San Francisco company and launch its product in New York City, they built a venue, or they set up a venue, and there Bowen was fussing about individual sort of brand imaging and marketing aspects such as the venue flow. You can see that on page 4023, how to address to attract the cool crowd. You can see that as page 418, and the allegations in the complaint are those sorts of marketing efforts to seem young, to seem hip, are exactly what got teenagers and young people hooked on this nicotine product. And then if you look, when you look more broadly at their efforts to expand in New York, on page 603, Monzi's is on a email chain with 3 people. He's in a very select group of individuals about how to target New York City users in particular. So he's engaged in these marketing efforts about how to attract New York City users. Bowen sends around this strategy document that I think one of your honors referenced, and he talks about how at New York Fashion Show, for instance, there was a big splash because male models were
So let me just ask you, your claim is that they illegally targeted youth? That's one claim? And what about the claim about the content, the nicotine content? Is there anything connecting these individual defendants to that claim?
So this all started, and the unlawful marketing started immediately during the launch weekend, where there was the launch party and also other events in New York City surrounding the launch. So for example, when you look at pages like 104 of the record, which is the complaint, you can see the advertisements in Times Square. And what you won't see in those advertisements are disclaimers that Juul products contain nicotine. You won't see disclaimers that these products are highly addictive. That's because when they initiated this entire launch, the deceptive marketing and the unlawful marketing began at its inception. So when we are talking about these sort of New York connections and New York marketing schemes, those were deceptive since the very beginning. And I do want to make that clear. And the second aspect of that is, I think this case is on all fours with the Court of Appeals' case in high fashion wigs. And in that case, if I can just go over the facts really quickly of that, it was the same sort of setting where a corporate officer decided to appeal. And he said, look, the corporation was the one who engaged in an advertising or marketing contract with a New York corporation. I didn't really have anything to do with this. The allegation was that there was sort of fraudulent practices under the contract and under the advertising contract such that the contract wasn't performed. And he said, all I did was I personally brought the guarantee for the contract over to New York in the beginning, and I set up that business relationship. And the Court of Appeal said, well, that's enough to get you into New York's personal jurisdiction, because what you did was very significant. You brought this entire business relationship to New York with the idea that you would continue having an ongoing business relationship in New York. And that's why we think the Supreme Court very easily found that there were sufficient allegations and that the allegations were sufficiently supported to find the sort of bare minimum contacts that you would need for personal jurisdiction. What we don't have here is a motion for summary judgment. We're not here on trial determining whether there were, in fact, those sorts of contacts, at least at this stage, when what we have is the allegations in the complaint, and what we have are dozens of emails, other messages connecting these two individuals to New York-specific marketing schemes. We think that that is itself enough. The other aspect I'll say to that is, I think on some level, you know, when you look at these sort of emails, you know, there's no smoking gun that says, you know, today is the day we're going to market to youth, and that email's from Bowen and it goes to Monzi's. But when the thrust of their defense is that we have to sort of disclaim every single email. We have to say every board meeting and every board presentation wasn't really their idea and they weren't participating in it. And this email I didn't participate, and that presentation I didn't participate into it. I think you can draw an inference in favor of the state of New York at that point. Because if, for example, you happen to be at the scene of 20 different bank robberies in a row, and you know the state says, well, maybe you're a bank robber. Maybe you were involved in one of those bank robberies. I think that's a pretty fair type of inference to draw at this point. And so that's what we have here, really, is that sort of record. And I think if you follow high fashion wigs, you get to exactly the sort of result that we're talking about. My friend on the other side mentioned Gasarch, Coast to Coast Energy v. Gasarch. Those sort of cases have involved situations where plaintiffs have sort of copied and pasted allegations and complaints, or they've had sort of bare-boned allegations in their complaints without the types of supporting details that are involved here. And here we really have a lot of details about what happened during this launch and how significant it was that Bowen and Monzes were the dedicated spokespersons for Juul as a company here, that this launch was meant to cement their linkage to New York, and that in the coming years that both Bowen and...
But again, them personally or the company?
Them personally. They were the designated spokespersons, and that's on page 419 of the record. And they personally then, well, their whole point was to bring the company to New York in the sense of launching the product in New York. So perhaps that was the question, but we don't think that that aspect is significant. Of course, if you personally decide to bring the company to New York and the company comes to New York, then you've been involved enough for purposes of personal jurisdiction. But they also cultivated that. And there's one other aspect of that that I do want to point out. One of your honors asked about the marketing aspect of it. When the brand's image, I think this is very telling as well, when the brand's image started to go south, both Bowen and Monzes continued and stayed very, very involved. Monzes wanted to debunk various studies. This is on page 56 of the record. He was concerned specifically about New York news media on page 663 of the record. And then Bowen wanted to change the image of nicotine as a whole to make these e-cigarette products distinct from conventional cigarette products, and that's page 653. So for those reasons, we urge this court to affirm. Thank you.
Apologies, Your Honor.
Respondents' counsel had addressed the issue that I had brought up that I said I wanted you to speak to on rebuttal, and that was the media outreach and the PR activities. Thank you.
Sure. So starting with that, Your Honor, the media outreach, I think that at the launch event, on page 419, it discusses the efforts to set up interviews with the New York press, and then we've got some of the outreach to the Daily News. We don't think that's sufficient here for a couple reasons. The first is that in the primary one, is that the allegations in the complaint are not that Juul made false statements in its relationship with the press, but in its marketing, and we don't think that those interfaces with the press are sufficient. You know, my friend pointed to and said they were the designated spokesman for the company. If you look at 419, what you'll see is that it's a suggestion that someone be a designated spokesman at the launch event, and they suggest Monzes. That was at one event, and that was not about ongoing spokesman for the companies in every aspect. He said that they were specifically involved in the marketing. Of course they were. They were members of the board. They received these updates, and occasionally they provided comment, but that's not the standard for this court. They have to be the driving force.
But that goes to personal responsibility at the end of the day. That doesn't go to jurisdiction. The question is if they're in the state and whether it comports with due process. Maybe you're going to be able to prove that they shouldn't be held individually liable, but that's a different inquiry with respect to personal jurisdiction.
You're right, it's a different inquiry, but with respect, Your Honor, the driving force, the primary actor test, that's a jurisdictional test. That's what the court held in Kruger. That's what the court has said again in Gasarch and in Caribou and in Wolo. The question is whether they, and if you're going to impute all of JLI's conduct in New York to Mr. Bowen and Mr. Monzes.
No, I think the question is whether we should impute their conduct to themselves. We're not talking about other board members. I mean, they wrote these emails. They came here. They set up the launch. There's no question, correct? Are you denying that they did all that?
I'm not denying anything in the record, Your
Okay,
Honor.
so
What I-
we're not imputing anybody else's conduct to
So
them.
I'm
We're
happy to set
imputing their own
aside and
conduct.
say that all we're going to look at is the personal conduct of Monteith and Bowen. And with that, with Your Honors, I think that the connection to New York and the claims at issue, the allegations of misconduct are not there. My friend pointed to the looking cool at a party. That's a Slack conversation about what he should wear. The target audience, and you'll see this at page 376 of the record when Jewel launched, was 25 to 34-year-olds. Those are young adults, and they can be cool. But that doesn't show that Monteith or Bowen was engaged in any of the targeting of the youth. And the last thing I'd say, Your Honor, on personal jurisdiction, is that there are other people in the company who are doing this, and other people and outside folks who are working on marketing. You can look at page 249 to 250 of the record. You'll see the org chart with the chief marketing officer. Monteith and Bowen were kept informed of what was going on, but they were not the driving force, and I don't think their individual contacts with New York are sufficient. Could I say one thing, Your Honors, about the statute of limitations?
I'll give you 30 seconds, sure.
Great. I know we haven't talked about this morning. I just want to urge the court, if you get there, we think it's sufficient to dismiss, but if you disagree, I would ask the court to lay out the rules of the road, because the timing here really does matter. The Vaporize campaign stopped in 2015. The Smoking Evolved campaign ended in early 2016. So if you're not going to dismiss on statute of limitations grounds or personal jurisdiction, I would urge the court to lay out what are the timelines that should govern this case going forward.
Thank you. Thank you both. People versus Angel Garcia.
Good afternoon, Your Honors. May it please the court. Cameron Johnston from the Office of the Appellate Defender for Mr. Angel Garcia. Mr. Garcia's sentence should be reduced in the interest of justice because of the hardships that he endured during his childhood, the trauma-induced substance use disorder, and his strong family ties. Mr. Garcia experienced enduring...
Strong family ties at the time of the incidents which are the subject of this, right?
Yes, Your Honor. Mr. Garcia did have a family at the time. However, more than ever, because of his significant childhood trauma and growing up without the support of his father, he is recommitted to supporting his family as much as possible upon release.
Counsel, on the assault in the first degree, he got the minimum sentence?
No, Your Honor, he did not receive the minimum. He received several years above the minimum on that charge.
But then there were other charges. This was two different indictments, right?
Yes, Your Honor.
Well, two separate pleas, so not consolidated. And on the conspiracy second degree, he neither got the minimum nor the maximum. He got somewhere in between?
Yes, Your Honor. He received...
3 to 9 years?
Yes, Your Honor. Exactly. And now, because of these very significant mitigating circumstances, his sentence should be reduced. First, because of this childhood trauma that he experienced, and that's because the dysfunction associated with cycling in and out of the foster care system and group homes laid the groundwork for later negative life events that simply cannot be disconnected from his offending behavior.
Was his childhood impact, was that presented to the sentencing judge?
It was in the paperwork. However,
so the sentencing judge already considered that and still reached whatever conclusion he reached in terms of sentence?
Well, it is in the record. However, the defense counsel at sentencing did not raise these arguments on the record, and they are so significant that they should now be considered. And, you know, moreover, being funneled through the foster care system is directly related to an increased vulnerability to contact with the criminal legal system later on in life. And while it's certainly no excuse for the harm that he caused, his childhood does provide helpful context to center the hardships that he has endured to this point. He experienced constant instability in a system notorious for being a pipeline into prison. And all of this happened during the most formative and impressionable years of his life. And moreover, Mr. Garcia sustained very serious physical injuries that resulted in his disablement and chronic nerve damage. And coping with this serious and protracted pain, he became addicted to pain relievers. And his criminal history must be viewed through this lens and cannot be separated from his trauma-born dependence on substance use, which is why his sentence should be reduced so that he can more quickly receive community-based, individualized treatment. Moreover, Your Honors, he accepted responsibility for his actions and he pled guilty. This was a negotiated plea, but he didn't plead down.
What is the reduction that you're asking?
What was that, Your Honor?
What's the reduction that you're asking? You want the sentence reduced. Which sentence? Which felony? Which one?
The assault, reduced to at least 7 years, and the post-release supervision reduced to 2.5 years.
So right now, he has 8 years on that felony and 7 years PRS. Is that right?
5 years of PRS, Your Honor.
5 years PRS. And you're asking for 1 year reduction there to 7 years, and the PRS reduced to 3 years.
To 2.5, Your Honor.
2.5?
Yes.
How old is he? Sorry.
He's 42, Your Honor.
Any other questions? Thank you.
Okay, I'll reserve my time.
Oh, I'm sorry. I thought you were done. No, go ahead.
No, Your Honor, I'm done. I will reserve
Okay.
the rest of my comments for rebuttal.
Okay.
Thank you.
Good afternoon, Your Honors, and may it please the court. My name is Andrew Chung, and I represent the respondent, the people of the state of New York, in this case. To begin, defendant validly waived his right to appeal, but in any event, even if he hadn't, defendant's sentence is extremely fair and indeed lenient, given the severity of his crime.
In his waivers of right to appeal, the first day that he took the waiver, there was no written waiver executed, right? Because it wasn't available?
Yes, Your Honor. The written waiver was not available on the 27th of February. I believe that's what you're referring to, and so they executed those the next day. But however, I'd also like to point out that on the 27th, Justice Claude confirmed with the defendant that his plea to the assault case would not be finalized until he signed written waivers and until he pleaded guilty to the conspiracy case. So I'd like to turn to, as a preliminary matter, the violent and serious nature of defendant's crimes. Defendant, while out on bail for a narcotics trafficking conspiracy, committed first-degree assault, getting into a scuffle outside of a nightclub, slashing an individual in the face with a knife, resulting in a 3/4 inch wide laceration running from his temple to below his mouth. As I mentioned, defendant was on bail when these crimes happened. Defendant was part of a narcotics trafficking conspiracy in which he personally arranged the sale of over 0.5 kilogram of cocaine, which is, as I'm sure this court knows, is a substantial sum. Moreover, given the potential sentences that defendant faced on the assault and conspiracy cases, his sentence was more than fair. As this court mentioned earlier, the minimum for first-degree assault is 5 years, and he received 8. The minimum for the second-degree conspiracy case is 1 to 3 years, and he received 3 to 9. Given this, defendant should not now be heard to complain that his lenient sentence was somehow excessive. It certainly does not meet the threshold of unduly harsh or severe.
Well, what about his personal issues?
Yes, Your Honor. So referring to the personal issues, I'd like to respond to each one of them in turn. So opposing counsel mentioned that he has several gunshot injuries. As this court pointed out earlier, he had these injuries at the time he got into the scuffle in front of the nightclub and when he slashed the individual in the face with a knife. So if those injuries did not prevent him from taking part in a large-scale narcotics trafficking conspiracy or going out to a club and slashing somebody in the face, I don't think that they would deter them in the future. And as this court mentioned, he had family ties prior to this, the instant crimes in this case, and they did not seem to deter him in the past. As an additional matter, I'd like to point out that defendant stated in his interview with probation that he has no interest in receiving counseling for his drug problem. And I'd like to also turn to defendant's long criminal history, which justifies these sentences. Defendant is not a first-time offender. He has 12 prior convictions in New York State, including 2 felonies for attempted grand larceny and third-degree criminal sale of controlled substances. He also has a history of bench warrants and 1 probation violation.
And those are taken into consideration in the range, right?
Yes, Your Honor. So the sentencing court below had access to a great deal more information than we have here. The sentencing court, as this court knows, is in the best position to determine the appropriate sentence for an individual based on the severity of their crime.
But my point is that the sentencing structure takes into consideration if a person is a predicate or a repeat offender or whatever it is when the range is determined. So that 1 to 25, for example, is the range for him, this particular individual with his criminal history.
Yes, Your Honor, I believe so.
Thank you.
Finally, the sentencing court was well aware of all the mitigating factors that defense counsel raises. In fact, these likely contributed to the leniency of his sentence. Turning to the appeal waiver, it's clear, given the facts of this case, under the totality of the circumstances, defendant's waiver of appeal in both cases is knowing, intelligent, and voluntary. First, as a condition for acceptance of defendant's plea, he was required to sign written waivers that clearly set forth his rights and supplemented his oral colloquies. In addition, we have many on-the-record acknowledgments from both defendant and defense counsel that he understood the nature of the rights he was giving up. On the 27th, as earlier mentioned, Justice Clutt informed the defendant that his plea to the assault case would not be finalized until the second day. And on the second day, defense counsel and defendant actually had a conversation, and defense counsel stated on the record that she had explained to the defendant the nature of the appellate rights and that he had assented to both waivers. Justice Clutt also noted himself that he had personally observed the defendant review and sign the waivers in open court. In addition, given defendant's age and experience and the reasonableness of his bargain, the appeal waiver was knowing, intelligent, and voluntary. If there are no further questions, we rest on our brief and ask that you affirm.
Thank you.
The violent offense was a one-off event that was entirely aberrational, and especially when considered in context.
But his criminal history wasn't only, or I should ask, was it only drug offenses? Were there no violent, was there a robbery? Weren't there a couple of robberies early on?
There were no prior violent offenses. They were entirely drug and larceny related.
So I thought it was a robbery. You're saying it was a larceny?
I believe so, Your Honor. He only has misdemeanors besides 2 felony convictions in 2000 that are drug and larceny related. And moreover, Mr. Garcia was admittedly consuming alcohol at the time of the offense, and it was the result of a personal romantic dispute between the 2 men. Briefly, if I may discuss the appeal waivers.
Yes.
Okay. Both appeal waivers were invalid because the lower court misadvised Mr. Garcia that an appeal waiver was a complete bar to taking an appeal or seeking collateral relief, and because the court failed to explain to Mr. Garcia that the right to appeal normally survives a guilty plea. And both of these components are crucial to a valid appeal waiver. If there are no further questions, I will rest on the briefing and ask this court to reduce Mr. Garcia's sentence.
Thank you. Thank you both.
Thank you.
118 Duane LLC against New York State DHCR.
Good afternoon, if it pleases the court. My name is Joseph Goldsmith. I represent the appellant, 118 Duane Street, who is the owner of the building in question. After this appeal was perfected and the brief, underlying brief submitted, but before the reply brief was submitted, this court actually issued a decision in September in First New York LLC versus the DHCR, substantively deciding the issue that's before your honors today. That issue, which had been decided in First New York LLC versus DHCR, and which is also the subject of this underlying appeal, is...
That case, I agree with you that that case is important, but it doesn't seem to me that it addresses the question of whether your client's proposal constituted a demolition and whether DHCR was acting within its discretion in deciding that it was not a complete demolition. And I don't see that that issue was at all raised in our prior decision.
So the First New York decision stands for the proposition that an owner need not show what ultimately may or may not be constructed on the site.
Right. But the issue in this case is not, that may be part of the issue in this case, but the other issue in this case is whether a demolition that is not a complete gutting of the interior can be found, that such a proposal can be determined by DHCR without being arbitrary or capricious to not be a demolition. And that issue was not raised in the other case, correct?
That is the second part, Your Honor. I do agree with you, and that remains outstanding on the cross appeal.
We understand.
That means outstanding on the cross appeal. The underlying appeal, inasmuch as the lower court actually did agree with the owner that the plans were sufficient to constitute a demolition, was not subject of the owner's appeal.
What about the issue about, because there's another component, a financial component that needs to be shown in terms of money that's available for whatever construction is going to take place or demolition. And the funds that were presented weren't specifically earmarked for anything, they were just funds.
Well, so the underlying order from the rent administrator and then the petition for administrative review, both by DHCR, didn't actually say that the owner didn't present funds sufficient to constitute and complete the demolition. What the DHCR had found was that the funds were not sufficient to show the construction of a new building. In the Article 78 proceeding, the Justice James, I believe, had said that the funds hadn't been earmarked, but that actually was not the issue that had been decided by the DHCR. The DHCR was issuing its decision saying, we believe that you need to show the funds sufficient to construct a new building and plans for the construction of a new building, and since the funds that you gave are only for the demolition, we do not believe you met the standard. But I will say, as to the idea or the concept that you're raising, Your Honor, about whether they're earmarked or not, this particular owner submitted to the DHCR in its underlying application a copy of its bank account, which it disclosed were dedicated to the project.
So aside from it saying it's dedicated to the project, what else was there to show that it actually was dedicated to the project? Was it in escrow? Was there no other use that could be made of those funds?
So for the financial ability, what the owner showed is, here is a...
He puts in a bank statement that says, I got $4 million. What else? Because obviously, the fact that today he has $4 million is not, tomorrow I have $4 million, and I'm going to spend that $4 million on the demolition. So other than putting in the bank statement, what else did the owner put in?
The owner put in that the bank statement is a separate account. It was the savings account, not the operating account. It put in a statement from itself that these are dedicated to the project. It also showed that it owns the building outright without any mortgage.
And then didn't the DHCR see that money was going in and out of that account, like thousands and thousands of dollars?
I believe it was the difference between 4.7 and 4.8 on a demolition that cost 1.2.
Okay, but we're talking about $100,000, right? Which sort of raises the issue, or at least is an issue that the DHCR can look at as to whether or not this is actually money that's going to the demolition.
I don't disagree that they can't look at it. I'm saying that you have
Are you saying it's arbitrary and capricious that they found that this wasn't sufficient to show that that money was earmarked for the demolition?
The underlying rent administrator and petition for administrative review didn't speak about the money being allocated to the demolition at all.
I thought that the commissioner relied on DHCR's operational bulletin from 2009,
Yeah.
which stated that no demolition application will be accepted unless the owner has submitted proof of financial ability to complete such undertaking. Wouldn't that imply the undertaking of the demolition and not just funds sitting in a bank account, not specified for anything?
Well, so in First New York, the actual proof that was submitted by that owner was a bank account that they had named demo account. There wasn't anything further in First New York other than this is
The issue in that, because, you know, I sat on that bench, right?
Yeah, I watched it.
The issue in that case was not whether the funds were for, whether the DHCR could rely on the fact that the owner didn't show what it was going to do with the property after it was demolished. That's what that whole case is about. That was the whole point of that the statute was amended to say that you don't need to do it. It had nothing to do with saying whether or not you can just put up a bank account and say, I've proved that I have the funds for the demolition.
But after Your Honor and the court said in that case, you don't need to show the construction or the finances for construction, what were you left with? You were left for proof of the demolition. And for proof of the funds necessary to do the demolition in First New York.
There was no question in that case. That wasn't the issue. That's my whole point.
I understand, but here as well, I don't think that anyone has ever questioned that the owner doesn't have the financial capacity to do the work.
Counsel, I'd like to follow up with my colleague here. Going back to that 2009 operational bulletin, because it also indicates that evidence of financial ability may include a letter of intent or a commitment letter from a financial institution. Did you present any of those documents?
No, see, actually, cash in an account greater than the cost of the demolition has been held by the DHCR to be sufficient proof of the financial ability to do the work. Whereas a letter of intent is actually a lesser standard. That's a bank saying, I promise I will lend you money. But if you have an owner who has a building without any mortgage, has $4.8, $4.7 million on a $1.2 million the demolition project, it's not necessary for.
But let me ask you, isn't it fair for the DHCR to say without any restriction on that money that tomorrow you're going to go buy another building with that money and not use it for the demolition? How can the DHCR be sure that you're actually going to use that money for the demolition?
Well, there's actually penalties in the statute that say that if you don't do what you intend to do, you don't do what you say.
You have to start by proving it, right?
And I understand. And the owner here submits an account with 4.5 times the money required to do the project. At no time did it ever decrease below 4.7. He's submitted a representation to the DHCR that these are the funds dedicated to the project. He has no extraneous equity issues on the particular building. DHCR has made 12 separate requests for additional information, and they never go further than what was submitted by the owner. They issue a decision that doesn't say anything about the funds not being sufficient proof of the demolition. Their decision only talks about the construction of a new building. And the standard is only a good faith basis and a good faith showing. So if the owner comes forth with this evidence to say, here's my good faith showing if I have the money in an account that I'm saying is dedicated for the project.
Just end the sentence.
Sorry?
Just end the sentence. It was a long sentence. I think we got the point.
Therefore, it is, a good faith basis that's been presented.
Okay, good. You have rebuttal.
Thank you.
Yes.
May it please the court, Your Honors. My name is Jeff Kelly, attorney for the DHCR.
All right, so I'm going to ask you right away. Do you agree with counsel that there was no issue that they had the money for the demolition?
If they had the money, Your Honor, they had a bank account, which you pointed out. That's exactly what they had. Now, the issue is that it's not segregated. In fact, I just want to say the DHCR did find, because counsel said that they made no finding about it. In our par order, we found that there was no letter from the bank indicating that such funds were specifically segregated for the demolition project. So there was no such, there is no, we look for some evidence. Otherwise, we don't know what's going on. As Your Honor pointed out, it's a bank account. You know, something else could come up. It could be, the money could be moved out at any time for any purpose. You know, there's nothing tying the person to the project. We'd like to see
So
that.
that's, I just want to ask you, if you, just to pinpoint it, do you disagree with counsel that part of the reason why you denied is because there wasn't sufficient evidence of money earmarked for the demolition? Or do you think you were talking only about the next building?
No, we're talking about this project as well, Your Honor, as the next building. We did talk about both. And I understand because of what happened in First New York with the next building is not really maybe as relevant right now. But we do look at it absolutely for the project as far as the building itself. We want to see, because it's, you know.
And then can you address the
Demolition.
the demolition? Yeah.
Yeah, I mean, the whole
for
thing, the whole demolition, and it goes back to good faith. It's in the law that we'd like to see an owner has good faith with the application, and what that means is that they have an honest intention to carry through with what they
Well, is there something about this demolition that led you to believe that there was not good faith?
Well, yes, Your Honor. Pretty much the whole thing. I mean, the case is not very strong. Even in the initial plans, they had things in there which didn't show a complete gutting in line with Peckham v. Calogero. Now, we didn't appeal that part of the court's below order, but when you look at the whole thing too, I mean, it's just between that and the financial part. The you know,
What was it about the demolition that you didn't think met the burden of showing a real demolition?
That there was not a complete, as stated in Peckham v. Calogero before the Court of Appeals, that there was not a complete gutting of the entire interior of the building. They left a corridor through the side of the building and leading to a staircase going out. And I think it was actually even connected to the building next to it as well. It doesn't fit the standard definition that this court has upheld, I think, in Calamaris and also in Peckham.
In other words, you look to the sky and there's nothing.
Yes, Your Honor, right. You're
The
supposed to
four
stand-
sides maybe, but there's nothing in
Right.
between. And this
Nothing.
has something.
Has something. And, you know, court below let it go, but I don't know if that's correct, Your Honors.
And the DHCR would be in the best position to determine what, in fact, is a demolition underneath their standards, right?
Oh, yes, Your Honor. Yeah, you know, in Stone v. Calderon, the seminal Court of Appeals case, that DHCR has exclusive vested jurisdiction to determine these demolition matters.
And so
we should
your
be-
determination is that here, the demolition does not square, so to speak, with matter of Peckham, because it remains, a part of the building remains. Is that right?
Yeah, yes, that is correct, Your Honor. I do think that is correct. It does not square with Peckham's requirement of having a full gutting of the entire interior.
Counsel, if I may, I'd like to go back to the financial ability piece because
Yes, Your Honor.
now in this Article 78 proceeding, the appellant had produced Capital One bank statements, right, from January 2016 through December 31st, 2017, showing more than 5.5 million withdrawals for that period, leaving, in essence, even less than 800,000, right?
Yes, Your Honor. Yeah, which does point out the fact, and I think some of that evidence came in during the Article 78. It wasn't before the court
I know.
below, so it's not really part of the record.
I understand.
But it does point out, and I think what you're saying there is exactly right, that money was coming in and out, and who knows if it would be there to actually do the demolition. And it actually gets to the seriousness of the whole thing. Is this a serious application before us? And the DHCR is in the position to decide that. That's what we're doing here. We're talking about tenants five tenants who are going to be out of their apartments. These units are removed permanently from stabilization, and we have an interest to see what's going to happen with that going forward. And so we ask that the owner, show that you're serious about this. You know, we like to test. You want to do the demolition? Okay. Well, show us exactly how you're going to do it. Give us the proof. You know, we don't ask you for a bond. We're not going over the top, but we want to see something. We want to see that you can show your intention is honest and true.
Thank you.
Thank you.
Good afternoon. My name is David Rosenholz. I represent 4 of the rent-stabilized tenants in the building. My clients, my youngest client is in her 60s. My oldest client is 89 years old. She's lived in the building for 44 years. This landlord filed an application at the HCR based on allegedly approved plans by the Department of Buildings. If you look at those plans, if you look at 68 on the record, the Department of Buildings does not review demolition plans. They rely on the certification of the architect and the owner. The plan on itself, the document itself, the approval says no plan examined, which means nobody at DOB ever looked at this plan. It's important to focus on that issue. Number 2, in terms of financial ability, the judge is right. At one point, there was less than $800,000 in that account. It was an operating account, general operating checking account, which the owner could use for any purpose and did use for any purpose. That is not the standard. The HCR has the responsibility and has the right to make a determination as what you have to prove, what your obligation is. The landlord in this case did not meet that obligation. In terms of the landlord's application, the DOB, I think it's important to point out, the landlord, with your plans, you file a PW1, which is sort of a document which completes the plans and indicates and has certifications as to what the plans indicate and certain representation to the HCR. One of the representations on those plans, on page 78 on the record, the owner has to indicate whether the rent control or rent stabilized tenants in the building. This landlord certified that there were no rent controlled or rent stabilized tenants in this building. Okay. No rent stabilized tenant. In addition, there was, by the way, you can't say he was confused because that certification is less than 1/4 of an inch from the statement that he made there were no rent controlled or rent stabilized tenants in the building. In addition, if you looked a little farther, another 1/4 of an inch, he would have said, falsification of any statement is a misdemeanor and is punishable by a fine or imprisonment or both. This is what the owner falsely certified. When we pointed it out to DHCR, 2 years later, after the plans were approved by the Department of Building, without an examination, he filed a new PW1, okay? But the plans, the approval he relies on was an approval, again, without an examination based on a lie and a misrepresentation. If I may, in terms of demolition, the standard for demolition, which is my cross appeal. The standard of demolition since 1984 has been Villas of Forest Hills, which was affirmed in Peckham, but by the Appellate Division of the Court of Appeals. The standards are very simple. You can leave the 4 walls, outside walls, all interior portions of the building have to be demolished. When you stand in the basement, where the basement was, you look up, you see the sky. And every portion of it, you do not leave a portion of the building. This landlord was leaving at least 20% of the interior of the building. Obviously,
So, wait, say again, 20%?
20%. If you look at the plans and you see with the plans, I mean, they're small, you know, the plans are very tiny, but if you look at the plans, 20% of the building, of the interior building was going to stay there. I'd like to deal, if possible, with First New York, and I know Your Honor was sitting on the bench. Okay? I watched the argument, and 2 of the judges asked the lawyers, are there any cases on this issue? And both lawyers said there were no cases on this issue. Obviously, they haven't been around long enough. Okay? In 2003, my case.
But that was before the amendment of the statute. That was before the amendment of the statute.
No, it's not. The amendment was in 2000. 2000 is the amendment. In 2003, Calamaris against 23 Second Avenue.
Oh,
We were
yeah,
in the
yeah,
middle of-
okay.
We were in the middle of hearing at the HCR, and we served a subpoena to try to get certain documents. We went to Supreme Court, the judge would not enforce the subpoena. We appealed to the Appellate Division. The Appellate Division did not enforce the subpoena. But I'm reading from the decision of the court. The authorization the defendants seek requires a showing of a good faith intention and financial ability to construct a new building on the site of the building in which plaintiffs live. Okay? Which means the court at that point, this court at that point, defined what the obligation is. So I'm just pointing that out in terms of First New York and the decision First New York. Because the decision First New York is most respectful, disastrous. It means if I'm a landlord,
okay.
okay, if I'm a landlord and I have 50 rent-stabilized tenants, theoretically, I go to the Department of Buildings, I pay an architect a couple of $1,000s to prepare a plan. The Department of Building does not review the plan. They accept it the way it is. I then do what this landlord did not do. I actually opened an account in which I put $2 million in to demolish the building, and I just succeeded in evicting 50 rent-stabilized tenants in New York. Okay, that is the effect of that decision, possibly the effect of that decision. It's not, I'm just saying
okay,
that
but-
somebody who doesn't study of law, I'm mentioning that. It's not really relevant to the case in this case. Obviously, the issues can be determined on.
I see, you want to yell at me about the case, I get it. Okay, thank you.
Thank you.
So, point by point on a couple of issues. Your Honor mentioned something about withdrawals and $800,000. It's actually, the owner opened a second account. So the accounts that you're looking at with 800 is in addition to the account that already exists with 4.7. It's not the same account if you look. One is from Signature, one is from Capital One. It's a second account that has been additionally funded. To talk about,
How do we know that that's dedicated to the cost of the demolition?
because they didn't close the underlying account that they presented to the DHCR, being the account that has the money dedicated to the project. That is the same amount of money, the same account that's been presented, with the statement from the owner saying that these are the funds dedicated to the project. As to the standard of demolition, we have a side-by-side comparison of what the building looks like today versus what the building would look like after the demolition. It's on page 530 of the record, and you can see that the only thing that is remaining, the entire building is being razed to the ground. There is no portion of any part of the building, the outer walls, the floor joists, any apartment at all, except there's an emergency staircase that's going to go 2 stories to the neighboring building for their fire escape until a new fire escape can be created. That's the scope of the demolition that we're talking about here.
But our cases call for say that a demolition, that DHCR has decided that demolition requires a total gutting of the interior. I'm looking at page 530.
Yes.
It's not a total gutting of the interior.
That is not the interior of any building or an apartment. That is an emergency staircase.
I understand, but it's not a total gutting of the building.
But the standard is not a total gutting of the building. The standard is the ability to stand in the cellar and see sky.
Right,
And you
if
can stand in the cellar and...
Excuse me, if you stand on the southwest corner of the basement, you would not see the sky because there would be a staircase above you.
There are cases that have come forth that says that's more than sufficient. I cite few in the brief. Jack LaLanne, Biltmore is one of them. There's a couple of other cases that all stand.
All Court of Appeals cases?
Appellate Division.
Exactly. Matter of Peckham is a Court of Appeals case.
That's
the case that says you should be able to stand and see the sky. So
Peckham also, though, was not a complete razing of the building to the ground. Peckham also left the outer walls, left floor joists in the building. There was a staircase left in Peckham. All it is with the floor joists removed and with the roof of the building removed, that you're standing there and you can see up to the sky. And it's the same thing with this demolition plan that just has a 2-story emergency staircase for the building next door. all the walls, everything else is gone from this building, and that's shown in the plans.
Right, but so it's not an interior gutting. It's not a gutting of the entire interior. I'm just having trouble with understanding how you think that fits within those words.
I believe it does. The Supreme Court actually agreed with me and said that this was constituting a demolition. We have
Thank you.
the cases that we've
Thank you.
cited.
I've given you much over the time.
Thank you very much.
Okay. Someone else has rebuttal. Only one person has rebuttal.
Okay.
You don't have to use it.
Yeah, I'm trying to think if there's anything else to really add. I think that the Peckham case stands on its own, and I don't think I could really add to it, unless you wanted to talk anything else about any other questions, or otherwise I'll stand on my submitted
Thank you
briefs.
so much.
Okay, thank you.
Thank you all.
Thank you.
Bloom versus Jacobitz.
May it please the court, Stephen Hilsenrath for the appellant, Chubb National. This is a relatively common occurrence type case. It is put forward that the court below erred in granting a summary judgment motion when triable issues of fact existed. In so doing so, the court did not properly interpret an alteration agreement, nor did it take into consideration the vast amounts of testimony and evidence, which...
And it's your position that there are questions of fact here?
Yes, Your Honor, absolutely. Would you like me to review those questions?
Any questions, further questions? Seeing none, that would be up to you. I see no questions from the bench.
Okay. For that, I will rest on my brief.
You have rebuttal, I think, if you want to use it when it's time. Thank you. Next.
Good afternoon, Your Honors. Michael Tawil for the defendant, respondent, Dediad Construction. Simply put, there's no basis to overrule the summary judgment in the lower court. The record is completely devoid of any evidence of negligence on the part of Dediad Construction in the happening of this flood. They left 2 days before the flood occurred. The co-defendant...
Isn't there an alteration agreement here where you...
No, there's no agreement. That's actually a misnomer. There is a guideline that's imposed by the building.
I'm talking about the alteration agreement. You're talking about the same thing. You're just calling it something else, right?
Yeah, but I think it's an important distinction. It's not an agreement. It's a guideline. This was not an agreement.
The agreement required that you procure insurance?
The guideline did state
Did you do that?
Yes, we did. Because the tenant, Jacobowitz, said we had to. It was part of what we had to do. It was part of what she had to do.
Did you also agree to comply with the guidelines, with the renovation and alteration guidelines set out in the agreement?
Well, in the guidelines, and again, it's not an agreement.
Did you agree by signing it to comply with the renovation and alteration guidelines imposed by the building?
Yes, and there's nothing to show that we didn't do that. The real issue here is the reading of that guideline as the appellant wants this court to hold absurd. This court held, and I believe Judge Kennedy was on the bench for Wells Fargo versus Lloyd Syndicate AGM, shows that when you hold, when you're reading a contract, you can't have an absurd result.
But doesn't that agreement also provide that the contractor, that is your client, shall be responsible for the prevention of hazards to personal property?
All hazards, all. The word all is in there.
Well, it's important to note there are a lot of words in this document, including during the work. During the work. This didn't happen during the work. This happened on a weekend. My client left the premises on a Friday in perfect condition. Winnick showed up on a
It doesn't
Saturday.
say while the work is going on, it says during the progress of any work.
Correct. There was no progress happening.
Well, the work wasn't done, was it?
It wasn't done.
So it's during the progress of the work.
Listen, as the Supreme Court properly noted, an airplane could hit the building.
Well, that's
during
why
the
we're
progress
here
of
to
work.
review it. And from what a reading of this, I'm sorry, the other party is suggesting there's an ambiguity to it. You're saying there's not an ambiguity.
Well, I'm saying there is a lot of ambiguity.
Well, then is there the ambiguity? There's an issue here, right? Because we need it to be clarity.
Not an issue that's.
What does prevention of hazards mean? How is that interpreted?
Well, the question that the Supreme Court said was, we didn't do anything that didn't prevent a hazard. We didn't do anything. We weren't even there. We weren't there when this occurred. The facts are
I'll give you 30 seconds, and then it's done.
no one knows what happened here. My client left the premises on a Friday. Everything was fine. Winnick showed up on a Saturday to take photographs of the premises. Everything was fine. Sunday morning, the neighbor wakes up, and there's water coming from a toilet valve that had been opened.
There must be poltergeist. I don't know what else
This is
to
a
say.
432 unit building. Anything could have happened. There's evidence in the record that the next door neighbor, Bloom, was spying on Winnick when he was in the apartment on Saturday night. For all we know, he could have commented.
Wait,
Sounds
isn't
like to me.
the water came up from the toilet that was there
There's a
one day
toilet
and then
valve that
gone
was
and
opened.
then gone another time? How did the toilet go missing?
I'm sorry?
The toilet. It was installed and then it went missing?
No, it was not. It wasn't installed.
Okay, so that, I'm hearing you say so many things that are different than what's in the record. You're raising issues other people have said, other parties have said differently. It sounds like issues of fact to me, but thank you.
Your Honors, I represent Ariana Contracting, one of the respondents, and here...
Ariana Contracting employee was Mr. Joka?
No, Mr. Gill.
Mr. Gill, okay.
On the record here, it is clear that Ariana should not...
I'm sorry, the plumber wasn't an employee of Ariana?
Yes.
And was it his testimony that he installed the toilet?
Yes, he installed the fixtures. By July 22nd, the fixtures had been installed and Ariana's Contracting's work had been completed.
So you say the toilet is installed, and the counsel for Detty, is it? Detty, just said the toilet wasn't installed. So
on
which
July...
one should we pick? And is it our job to pick it, or is it the jury's job to make that determination?
For purposes of Ariana's last involvement in this project was July 22nd, when the Department of Buildings appeared to the site, did an inspection of Ariana's work, and approved the work. We have on the record, at page 1776, there is the report from the Department of Buildings approving the work performed by Ariana. That was on July 22nd. After that, Ariana never returned to the site, and whatever happened after July 22nd, Ariana was not involved. So whether there was somebody who uninstalled the toilet after that, Ariana had no involvement in that, could not have had any knowledge of that.
And the other party says differently.
There is no testimony, there's no evidence that Ariana ever returned to the property after July 22nd. Between July 22nd and the date of the flood, August 2nd, when it was discovered, Ariana was not at the property at all. What we do know is that Ariana was there.
And you're saying Department of Buildings was there?
Department of Buildings inspected the project, Ariana's portion of its work, on July 22nd, and it was approved. After July 22nd, Ariana never returned to the project. Its work had been completed and approved. After that, a little bit over a week went by. Ariana never returned, but other parties may have, according to the evidence, other parties were at the site. Other things may have occurred after Ariana was at the property. Nothing in the record indicates that Ariana ever returned, that Ariana was negligent in its performance of its work. In fact, it had been approved by the Department of Buildings, And all of the proof, including the appellant's investigator's report, says there's nothing really wrong here. Apparently, there was the valve was open. We know from August 1st the valve was not open because Dediat was there. And I'm sorry, on July 30th, Dediat was there and it was not open. When the co-defendant Winnick went to the property on Saturday, it was not open. So we know for a fact that the days leading to the flood, the valve was not open. So we have a week interval between Ariana leaving the property and proof that the valves were not open and there was nothing wrong with the fixtures until the incident occurred. There's absolutely nothing in the record that implicates Ariana in this case.
Right, when you're saying there was proof, what you mean is one person said that, right?
Well, there is an incident investigation report from an investigator hired by the appellant. That report is, I believe, on page 1794 of the record, and the investigator lists the incident and everything that was found, and nothing in there indicates that there's any negligent work or any problem with the fixtures that were installed by Ariana. So there's no finding anywhere in the record that anything that Ariana did contributed to the flood. If I may address the contract or guidelines issue.
You have 30 seconds.
There is no indemnity clause in this, even assuming for the sake of argument that there is an agreement, there is no indemnification clause, so there cannot be any contractual agreement to indemnify, and the law requires express, clear, and unambiguous language imposing a duty to indemnify. There's no such thing in these guidelines, and because of the absence of any negligence on the part of Ariana, there cannot be any common law indemnification either. For these reasons, the lower court's decision should be affirmed as to Ariana.
Thank you.
Thank you.
Good afternoon, Your Honors. My name is Peter Sayre from Moffett Kerman. On behalf of the respondent, Andrew Winnick, Your Honors, obviously the issue here is what caused the leak. Your Honors, the evidence that Andrew Winnick had presented to the lower court in support of its motion for summary judgment firmly established that there's absolutely no liability that can possibly attach to him.
Wasn't the only evidence that he presented his testimony about what he saw and did when he was there the day before the leak?
I'm sorry, Your Honor.
Wasn't the only evidence that he presented what he saw and did on the day before the leak occurred?
Yes, exactly. That is correct, Your Honor. The evidence that he presented.
There were no photographs.
He did present photographs, Your Honor, absolutely. The photographs that he had presented, one of the issues that was presented to the lower court was whether or not there were tiles that had been taped above the fixture, which, as depicted in the photographs, which I believe are at R22, between pages 22 and 27 of the...
Fell and broke the valve.
That's one of the theories that have been posited, Your Honor, absolutely.
But the tile would have been a decorative thing.
Your Honor,
Right.
Mr. Winnick had testified that he never taped that tile, and his testimony...
But he's the one who suggested that maybe a tile was taped.
No, he's not the one who suggested it, Your
didn't.
Honor,
I thought it was the janitor or
the Understood. Your Honor, Andrew Winnick's role in this matter was purely advisory. He was purely
Okay, so are you saying that he took a photograph of a tile that looked like it had been taped? Is that what you're saying?
No, Your Honor, I'm not.
I misunderstood what you just said a minute ago about the taped tile.
No, there was a theory that had been posited.
Yes, okay.
That someone had taped a tile, and Mr. Winnick had stated in, I believe, at least 2 or 3 affidavits.
That it wasn't he.
That he had at no point
that
did
I
he did take photographs, Your Honor. The reason why he had taken photographs was because he had done that for his client to show what the state of the bathroom was at the time when he had left it, which I believe was August 1st, 2015. The following day is when the leak had taken place. But he did take photographs, and the metadata shows when, in fact, they had taken it. He also states that when he left the apartment at that time, there was no issue, there was no problem. The water was not spouting out of the open, I guess you can refer to it as an open faucet or an open valve. But the theory was that someone had stated that they had heard, to refute Mr. Winnick's testimony, that they had heard that someone had told them that he had done that. So to refute Mr. Winnick's affidavits, we have nothing but hearsay, and we have conjecture that he had done this when there's absolutely no evidence. Everything is based on what someone had allegedly told someone else. So there's no credible evidence establishing that either Mr. Winnick.
And his photos showed the toilet?
Yes, they show an open valve, Your Honor. There is no toilet there.
Yeah,
When Mr. Winnick had taken the photos,
right, okay.
the toilet had not been there. Importantly, they also show that there is no tile taped above. And,
Yes, I understood. I understand what you said.
and if I also may say something further, Your Honor,
Wait a second, can I just ask you, does anyone admit that they took off the toilet?
don't know. I can't speak to that, Your Honor. I don't know who had taken off the toilet. All I can tell you is that Mr. Winnick did not. And more important, also furthermore, one of the individuals who had testified, I believe it was the super, that when he went to the site, he did not even see any evidence of tiles on the floor. That could be because maybe the water had washed it away, but importantly, the photos that
There's a lot of conjecture so far.
Absolutely, yes.
Yeah, okay.
But nothing concrete that points
Thank
to Mr.
you.
Winnick. Thank you, Your Honor.
Counsel, I do have a question for you. Would you agree that Ariana was not present after July 22nd and the Department of Buildings came and approved their work, and this accident happened some 2 weeks later? How did they stay in this?
Okay. Your Honor, it's a good question. The record shows that the building department signed off approximately a week before. The evidence also shows that the toilet was removed. Ariana was hired by Deddy. It was the only plumber on the job. Presumably, if somebody removed the toilet and had to be replaced, other than Ariana, I don't know who would have been installing that toilet. So while the evidence shows that it did get signed off, the evidence also shows the toilet was removed. So the question of whether their work was completed or not, that's probably something that Deddy would have to answer at trial.
Were there any expert affidavits? I didn't see any expert affidavits, were there?
There were no expert
So no one put in an affidavit that said, I inspected this site, there's no way my client did this?
No, Your Honor.
But even if the Department of Buildings did inspect it and signed off on it, that doesn't mean that that a toilet couldn't have been removed at the behest of the owner of the apartment for some reason, or by the plumber for some other reason.
That is correct, Your Honor. Nobody knows what the
But it was a
circumstances
week
were.
in between the time.
That is correct. It was there, and then it wasn't there.
Okay.
And then the valve to that toilet,
Anything?
everyone is, the testimony of the super was, when I went upstairs and I shut the valve, the flood stopped. So somehow the valve got turned on after the toilet went missing.
Okay. Thank you. Missing
Thank you
toilet.
very much. Rest on our briefs.
Okay. Thank you all. Star Indemnity versus Zurich American.
Toilets often go missing.
May it please the court. John Maloney of Jim Liano Moriel and Maloney on behalf of Plaintiff Appellant Star Indemnity and Liability Company. I'm here today to talk to you about the anti-subrogation rule.
Yes.
Doesn't get more exciting. Contrary to the trial court's findings, the anti-subrogation rule does not apply here because the third-party plaintiffs in the underlying action, Gotham and ZDG, and the third-party defendant in the underlying action, Western, are not co-insureds for the same risk at the excess level. There's no dispute that the two exclusions that apply here, the employer's liability exclusion and the contractual liability exclusion, bar coverage for the common law claims asserted against Western. The only issue, as recognized by the trial court, is whether the excess policies provide coverage for the contractual indemnification claim asserted against Western. If not, then the anti-subrogation rule does not serve as a bar. The issue comes down, and really just boils down to the issue of whether the insured contract exception to those exclusions applies here. The insured contract exception applies, unsurprisingly, to insured contracts. And that term is defined as that part of any other contract or agreement pertaining to your business under which you assume.
So, counsel, you represent Star.
That is
you just said. And Star is one of the three excess companies, right?
More than
Insurance
three, but
companies.
yes.
More than three, right, exactly. But the general policy, the general liability policy, you're talking about Western. The general liability policy includes Western. The CCIP within there includes Western, right?
Yes, there's no dispute that Western isn't insured under the I think you're referring to the primary policy issued by
The
Zurich.
primary policy with Zurich,
Yes.
exactly, that they are insured. And also, you're talking about the anti-subrogation rule, so you agree that an insurer can't seek subrogation from its insured.
As long as they're insured for the same risk under the same policy.
Exactly. And in this case, it indicates that there's a follow form in the main general policy that doesn't allow you, that is also included in the other excess policies, in your excess policy and the other ones, which is the same as the original in the general liability. Isn't that right?
Well, Your Honor, the Star Access policy absolutely does contain a follow form provision, but the follow form provision doesn't follow form in all respects to the policy below.
You're saying the follow form and the excess does not match that of the Zurich general
Absolutely.
liability policy? And how does it differ?
If the terms, conditions, or definitions differ from the Zurich policy, then the terms, conditions, and definitions of the Star policy govern. And here, there should be no doubt that the definition of you in the Star policy is different than the definition of you in the Zurich policy, in that the Zurich policy has a broad definition of you that includes all of the insureds under the Zurich policy, including Western. However, the Star policy and the policies above Star, including the Navigators and other policies, has a much more narrow definition of you that
Where does
only
it say
includes.
that? It's the same exact language. It says, same exact language. It says you, and it's got to follow the form of the original one in the Zurich one, which you just admitted refers to everybody.
In the Zurich policy, it does refer to everybody because Zurich has the broad definition of you. But the Star policy and the policies above have a much more narrow definition of you. The insured contract exception and the definition of insured contract, its use of you is limited to only the named insured in the Star policy. That named insured is ZDG. So therefore, for the insured contract exception to apply, it has to be a contract entered into by ZDG, not by Western. The result is that the anti-subrogation rule might apply on the primary level, but does not apply at the excess levels because of the more narrow definition of you afforded by the excess policies. And that's not an anomaly. This court has recognized in the past, most recently a year ago in the Vasquez decision, that excess and primary level policies not only have different terms, but that the anti-subrogation rule can apply at different levels. In fact, the federal case relied on by Zurich expressly finds that is not anomalous at all, and that is in fact common. Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Andrew Premisler. I represent Navigators Insurance Company. Navigators is the second layer excess carrier that's involved in this action. The primary mistake that the motion court made here was that the motion court did not look at the excess policy language, the specific language in the excess policies, and apply that language to the facts of this case to determine whether or not the underlying claim, that underlying contractual indemnity claim, that's the key claim at issue here, is covered in connection with the underlying action. If you look at the language in the excess policies and apply it to the exclusions and the exception to the exclusions, you come away with the inescapable conclusion that the policies don't cover Western, even though Western might be an insured on the primary policy or the excess policies. In order for the anti-subrogation to apply at the excess levels, there actually has to be coverage for that insured for the rule to kick in and bar the contractual indemnification claim or the common law contribution or indemnification claims. And the key difference there between the excess policies and the primary policies are these definitions that counsel alluded to the definitions of the words you, and it's very specific, the words you and the words named insured in the excess policies. If you take those specific definitions, which are different than the underlying primary Zurich policy, if you take those definitions and apply them here, the key provision in the policies, this insured contract exception, doesn't apply, and the entire claim, the contractual indemnity claim, the contribution indemnity claims, those are not applicable. Another one of the mistakes that the motion court made here is that in sort of the alternative holding here, the motion court essentially said that you don't have to look at the excess policy language at all in order to determine whether or not there's coverage at the excess level. You just have to look at the primary policies. That is a mistake. As counsel mentioned, one of the more recent cases on this issue, the Vasquez case by the First Department a year ago, that was one of the issues that came up there among a few issues. And there was a primary policy and excess policies at issue there. And the court determined that even if the anti-subrogation rule barred the primary, the coverage, the claim on the primary level, it still did not, if there's no coverage at the excess level, bar that claim. And there are several other cases that talk about that are cited.
Did those excess policies in the Vasquez case that you just mentioned, did they have follow form clauses or did they not?
Right, so they generally have the follow form clauses, and then they generally talk about when there's conflicts between the umbrella coverage and the primary coverage. And this is not an unusual situation. You often have.
So are you saying that they had follow form clauses or they did not in the Vasquez?
So I guess it depends what you mean by a follow form clause. So in Vasquez, you had a different provision in the excess.
So it wasn't the same clause. They didn't have follow form clauses in Vasquez.
Well, they didn't have, I think what you're referring to is like sort of a general follow form clause. The clauses except, to the extent that there's a conflict in the excess policy, that's what the clauses say. That's what our clauses say. If there's a difference between the excess policies and the primary policy, the conflict favors the excess carrier. You follow the specific language, the specific definitions, and it uses that specific word, definitions. You follow the definitions in the excess policies. You might follow the other, to the extent there's no conflict, you might follow some of the other provisions, but that's not really what we're talking about here. We're talking about specific provisions that conflict with each other. Those are specific definitions in the excess policies, and if you take those definitions and apply them here to the insured contract exception, you'll see that there's no coverage at the excess level. The language of the provisions, it's quoted in the briefs, it's cited in the record. I just try to point out that one of the issues doesn't appear to be in too much dispute, that is that you have to at least look at the policy provisions in the excess level to make this determination. One of the other things I'd like to point out before my time comes to an end here is that one of the other basis of the motion court's decision here was it looked at sort of what the perceived intent or the purpose of this CSIP, which is a contractor's controlled insurance program, which is not a contract that my client was a party to. And there's really no evidence in the record of what the purpose or intent of that CSIP was. But even if you did look at that document, that contract, and I'll finish that right here, you'll see that insurance manual, that part of the CSIP, that specifically says you have to look at the policy language itself. Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Mike DiMiola for the respondent, Zurich American Insurance Company. There's 2 points, and I'll kind of cut to the chase here. There's 2 points that I want to make Absolutely clear. And really, whether the anti-subrogation rule applies in this case or not turns on these two issues. The first is whether the excess policies provide coverage for Western at the excess level as it relates to the contractual indemnity claim. If the answer to that is yes, the next question is, does the anti-subrogation rule bar all the third-party claims against Western by ZDG and Gotham, including the common law indemnification claims? And to start with the second issue first, I suppose, just to kind of get that out of the way, the case law is crystal clear that in the context of a third-party action, particularly in the context of an underlying bodily injury claim, if that third-party action asserts common law indemnity claims and contractual indemnity claims, and there's common coverage for the contractual indemnity claim, all the third-party claims are barred, including the common law indemnity claim. And that's exemplified by the Ohio Casualty Insurance Company case that we cite in our brief. It's exemplified by the ACE versus American Guarantee case that we discuss in our brief. It's also supported by the Maximowitz versus New York City Board of Education case, as well as I would point you to footnote number 4 in the North Star Reinsurance case. As it relates to whether the excess carriers, particularly the Star and Navigators policies, provide coverage to Western as it relates to the contractual indemnity claim, at the end of the day, what the excess carriers are trying to do is have their cake and eat it too. They're saying that they follow form as to the exclusion in the Zurich CGL policy. In fact, they even say that they follow form as to the exception of the exclusion in the Zurich CGL policy. But then they attempt to rewrite the exception by changing that word "you" to mean not ZDG and all the other contractors that participated in the CSIP, but change it to mean just ZDG. The problem with that is that not only does the follow form language in particularly the STAR policy say that it follows forms to the terms, definitions, and conditions of the underlying policy, it also says that it follows form to the exclusions. And so to the extent that the STAR policy and the Navigators policy follow form to the exclusion, that includes the exclusion, it includes the exception to the exclusion, and it includes all the words that make up and give the exclusion and the exception meaning, including the word "you." If you all of a sudden adopt the exclusion and you adopt the exception, but then you change that word "you," you're essentially rewriting the exclusion and the exception so that it no longer has the same meaning. Well, if the excess carriers wanted to...
So basically, you're saying it's follow form except when it's not follow form.
Well, it's follow form except when they don't want it to be follow form. And so if they didn't want it to be follow form, they should have included a separate exclusion in the excess policies. That would have been a very easy thing to do, and it would have been a very clear way of saying, okay, we're not going to follow form as it relates to the exclusion and the insured contract exception, and we're not going to follow form in the sense that instead of covering all of the contractors for this risk that participated in this contractors controlled insurance program, which by the way was mandatory, they could have limited it to just ZDG, but they didn't do that. And even if the court were to find that the excess carriers were right, I would point the court's attention to the Union Carbide case. I think that case is particularly instructive here in the sense that the court there was dealing with a very similar situation where there was a difference between the underlying policy and the excess policy in terms of what the declaration said, essentially. And what the Court of Appeals said in the Union Carbide case was, when you have certain policy considerations at play, which are present here, in certain situations, the court should allow the follow form provision to prevail over potential discrepancies in the declarations, which is exactly what we have here. We have one declaration that lists the name insured as ZDG and all the other contractors on the project, and you have another declarations page that only lists ZDG, clearly not as thoughtfully as the declaration page in the Zurich policy. And I see my time is up. Unless anyone has any questions, I'll rest on our brief.
Thank you.
I think a couple important points need to be made, Your Honors. First of all, with respect to Vasquez, the decision doesn't reflect whether it was a follow foreign policy. However, Vasquez involved a CSIP program, just like the program in place here. I'd be very surprised if it wasn't a follow form, but it doesn't matter because if it were a follow form, let's assume for a moment it is, there was an exclusion in the high excess level policies that applied and for which the court found that coverage was unavailable under those high excess policies. That exclusion, which differed from the policies below, meant that even if it's a follow form, you go with the exclusion in the excess policy because that governs even in a follow form situation. Contrary to what counsel suggested, STAR is not looking to rewrite the exception. In fact, we're simply just looking to invoke what the policy itself says, because to do otherwise would be to render superfluous the language in the policy, and I know that's not what this court intends to do. If you look at the...
So the way that you are intending us to interpret the contract would actually go against the CCIP, correct? It would be antithetical to the whole point of the CCIP.
Not at all, Your Honor.
Yeah.
What
do you mean, not at all?
There's the suggestion that
There's
under
like,
a CSIP...
this, what you're asking us to do is against what the policy of the CCIP is, correct?
Absolutely not, Your Honor. There's a suggestion that a CSIP means that there's supposed to be uniform coverage, that the primary...
I think that's that's what it's supposed to be.
Then Vasquez would have been wrongly decided, Your Honor.
No, let's assume that Vasquez didn't have a follow form policy.
But Vasquez was a CSIP.
Right, but it didn't have a follow form. So all those terms weren't incorporated.
But Your Honor is suggesting that coverage has to be uniform in a CSIP, and that's simply a fiction. That's not true at all. In fact, the policies all contain different terms, different exclusions, which separate and apart from the definitions. But I just wanted to bring your Honor's attention to the definition, to the term in the STAR access policy, which says very clearly that except for the terms, definitions, conditions, and exclusions of this policy, the coverage provided by this policy shall follow form. If not for the term definitions, then the definitions in the STAR access policy would have no meaning. That language would be superfluous and would not have any significance. I suggest that is not the case, and that the definitions of the STAR policy must be applied, even when they appear in exclusions in the underlying policy.
Thank you.
Thank you, Your Honor.
Very briefly, Your Honors. The excess policies follow form only to the extent that there's not a conflict between, among other things, certain definitions. That's what the policy says. And the Court of Appeals case law cited in the briefs, the motion court was supposed to follow the language in the excess policies to determine whether or not there's coverage, the key aspect of the anti-subrogation rule here, whether or not there's coverage under those excess policies. And counsel made a big deal about saying we could have done this, we could have done that in the excess policies, but they did do it. They did, because they changed the definitions, and the change of those definitions is key to whether or not the exclusion and the exception to the exclusion applies. It's inherent in every exclusion or every policy provision that there are going to be words in those exceptions, in those exclusions, and the definitions in the policies are what defines the words in the exclusions and in those exceptions. So it makes sense that in order to change what those exclusions or exceptions to the exclusions mean at the excess level, you change the definitions, and that in effect changes how those exclusions and exceptions to the exclusions apply at the excess level. If there are no more questions, thank you. The rest on my briefs.
Thank you. Thank you all. People versus Andrew Blake.
Good afternoon, Your Honors.
Good afternoon.
Shaza Abushi Dalal, Office of the Appellate Defender on behalf of Andrew Blake. There are intractable factual conflicts on the papers comprising Andrew Blake's 440 motion and the prosecution's response. Factual discrepancies that cut right to the heart of the legal analysis required to resolve his conflict of interest claim. It was error for the motion court to prematurely deny his motion before affording him a hearing to resolve those factual disputes.
Which issues of fact do you claim were dispositive?
Well, to begin with, there are glaring factual disputes on whether defense counsel knew about his romantic relationship with her paralegal sister at all. In a self-serving submission attached to the prosecution's response to Mr. Blake's 440 motion, defense counsel and her sister belatedly claimed that she didn't know about their relationship. Mr. Blake clearly says otherwise, and his family members, Toshakia Blake and Dorothy Carter, do as well as Ronnie, defense counsel's paralegal sister herself, in a letter that is submitted, supplemented in Mr. Blake's 440 motion. That much is clear, and that dispute is on the face of the record, and it was error for the motion court to prematurely deny his motion without permitting those disputes to be resolved. Indeed, the motion court only paid lip service to accepting the allegations for their truth. In the same breath, the motion court calls retellings by Mr. Blake absurd and conflicting, and I quote, so incredible as to border on the comical, and then purports to base the decision on the acceptance of their truth. In reality, the record is really, like I said, riddled with these types of factual discrepancies. Ms. Carter recalls Ronnie telling her that defense counsel told her that Mr. Blake was, quote unquote, bad news and a gunslinger, and that he got what he deserved at sentencing. Toshakia Blake attested that the romantic relationship caused such strain between.
Well, on the record in the court's decision, did the court go into the heart of whether or not any relationship, whether she knew or she didn't know, but was there any proof that she sabotaged his trial based upon that knowledge?
Absolutely. The record points to two ways in which the animus that defense counsel harbored towards Mr. Blake might have infected her decision-making, and those are her failure to move to suppress the gun, and that was the only piece of physical evidence connecting him from his home in Delaware to the scene of the crime in New York City, and then particularly at sentencing, where defense counsel entirely abstained from putting forward compelling mitigating evidence that was at her fingertips. In fact, counsel that represented Mr. Blake in supplementing his 440 submission put forward very persuasive, compelling mitigating evidence from his family members that regularly attended his trial, attesting to the responsibility that he bore for his family members, his sister, his mother, his daughter, his impeccable work ethic, his generosity of spirit. And Mr. Blake was facing a 50-year aggregate sentence consecutive to an 11-year sentence in Delaware for the same conduct. For a man of his age, that's effectively a life sentence, and she put forward none of that. Mr. Blake was entitled to representation by defense counsel that wasn't angry with him because of his relationship with her paralegal sister. There's ample evidence in the record that he was denied that, and most importantly, there's no escaping the factual discrepancies that warranted a hearing.
Thank you.
Thank you.
Good afternoon, and may it please the court. Faith Petrolio for the people. The court should affirm defendant's conviction because any potential conflict of interest plainly did not operate on the defense. Starting with the suppression hearing, there's evidence that the relationship between defense counsel's sister and the defendant started after the suppression hearing took place. But even past that, defense counsel provided two different reasons why she did not request a suppression hearing. And so even if a conflict of interest existed, it didn't operate on the defense here.
What about the factual dispute as to the knowledge of the affair, I don't know what to call it, or the sister's affidavits and his family members' affidavits? Was the court allowed to assess them without having a hearing to deal with any credibility issues?
Well, first of all, the affidavits of defendant and his family don't allege any firsthand knowledge of the relationship between defendant and the paralegal sister. Additionally, there wasn't a hearing wasn't necessary in this case because the resolution of the facts, even if it turned out that all of the facts the defendant alleges were true, it doesn't give him a legal basis. It doesn't warrant the legal basis for the motion that he brought forth. In terms of the sentencing, defense counsel at sentencing did present some mitigating evidence, including the fact that his family was present for the entire trial. And she also provided a reason for not presenting more evidence in terms of the letters that he now raises on appeal. So again, even if a conflict of interest did exist, it plainly didn't operate on her defense. And therefore, there was no legal basis for defendant's motion, even assuming all of the facts that were true. If there are no further questions, we ask that you affirm. Thank you.
Your Honors, I'd like to address respondents' comments and the orders that they were made. First, in regards to there being evidence that the relationship started after the suppression hearing, there's no such evidence. There's a postmarked letter that's a week and a half into the trial from Ronnie to Mr. Blake that is very clear evidence that a romantic relationship was well underway. And Mr. Blake, in his statements, is very clear about the relationship having developed in the very early stages of defense counsel's work on his case. So that's in that regard. In regards to the two reasons that defense counsel put forward for not moving to suppress the gun, I think they're very telling in that they're meritless and shifting. First, defense counsel, in response to an email from Mr. Blake's counsel in his 440, said that she couldn't remember. And then she said that she didn't move to suppress the gun because it would have required putting the gun in Mr. Blake's hand or conceding standing, which by respondent's own admission is a complete misapprehension of the law. And at trial, she said that she, in comments to the court, didn't move to suppress the gun because she was collaterally estopped, also incorrect on the law. And then with regards to respondent's claim that Mr. Blake, Toshakia Blake, his sister, and his mother, and Ronnie in her own letter lack firsthand knowledge, all of their attestations are sworn. They're on the basis of many conversations with Ronnie and Mr. Blake, bearing close witness to his representation by defense counsel. Ms. Carter based her sworn statements on 20-plus visits at Rikers in the presence of both Mr. Blake and Ronnie. And just to conclude, I think at the very least, it is clear that a hearing was warranted to resolve the factual disputes on this record, and there's ample evidence that defense counsel's performance was infected by her animus towards Mr. Blake.
Thank you.
Thank you.
Thank you both. RTW Retail Wins versus Colucci and Umanis.
Good afternoon, Your Honors. May it please the court. I can take my mask off?
Yes.
Perfect. I can't breathe otherwise. Okay. It's very nice to be here. Thank you very much. I'm here, Ellen Werther from Wrestler & Wrestler, on behalf of Appellant RTW, seeking the reversal of the motion court's dismissal of the complaint, and in which the lower court granted the defendants motions to dismiss based on 3711A1 and 7. We believe that the lower court granted clear error of law. The proper standard for review by this court, we believe, is de novo under controlling law. And if I might, I just want to outline the basic parameters of our argument. As you can see, I'm quite old, been doing this a while. I have never, ever seen a case where the Second Circuit criticized the conduct of trial counsel. The trial court, Judge Rakoff, raked them over the coals for incompetent trial practice. And the motion court on a 3211A motion says, fine, it's no problem. Never seen that, but you never know. And what did we present? We have a detailed complaint setting forth specific departures from good practice that are alleged and supported in the trial record. We have, that is further buttressed by a detailed affidavit from a fact witness, Mr. Ratner, who was the general counsel of my client throughout the trial, up to the trial, during, before, after. That was jettisoned by the motion court here because they found it, quote, incredible. And then it was also buttressed by an affidavit by an experienced and prominent trademark expert, not for an opinion as to what constitutes legal malpractice, but as this court is well aware and has held many times, it is inappropriate to bring a legal malpractice action without some competent evidence as to what constitutes the standard of good practice and what the departures are, if any, and an expert opinion as to what the causation of those departures was, if any. We did all of that. And lo and behold, the lower court here rejected the fact witness making a finding of credibility that the witness was incredible in the motion court's view, then rejecting the expert opinion on the grounds that, two, one, you can't have an expert opinion based on something by an expert who was not an eyewitness. There is no law to that effect. In fact, 99% of all expert witnesses never saw anything. They rely on eyewitness testimony. And then he also rejected it because supposedly our expert reached conclusions as to what constitutes legal malpractice. Not the case. There is good law in this district.
So, counsel, what do you allege it was malpractice? Start with that.
Well, when I tell you, you won't believe it. So,
no, I've read the records, so it's not like I don't know. I'm just trying to get you to distill it because I have a couple of questions.
Not to worry, but I still can't believe it.
Okay, go ahead.
Okay, first, there were three defendants. One was the Colucci firm, the second was the Gabriel firm, and the third was the O'Reilly firm. Colucci, an older gentleman, also well-known trademark firm.
Okay, what is the malpractice that you are alleging?
What Mr. Colucci did was he failed to conduct any meaningful discovery. He waived the most important defenses in the trademark.
What defense do you think he waived?
He waived the crowded field defense, which is critical.
Well, didn't he cross-examine the plaintiff's witness about crowded field to talk about the mark?
No.
He did? I read testimony that he did. Are you saying that didn't happen?
That was not Mr. Colucci.
Oh, I'm sorry. Okay.
Mr. Colucci, only way to prove crowded, or the best way to prove crowded field, is to have evidence of other
weak marks. Okay, let's move on from that one. What's next from that? I agree. I agree with you.
He did no discovery, and therefore the crowded field defense was precluded.
And what's the next one?
The next one that he did was he did no, I'm sorry, it's just late. He did no crowded field. He waived the defense in terms of priority and enforceability of the mark. Contemporaneous case out of the Southern District, same time, same mark,
Right,
court held, not necessarily owned by the plaintiff.
okay.
That was what.
We agree, that's all part of that umbrella. What's next?
The next thing is he brings in Mr. Gabriel. And Mr. Gabriel says, oh, Mr. Gabriel comes in and opines with Mr. Colucci on the eve of trial, no problem, you have a good faith defense. And that will save you from any liability that might arise if you had a similar mark. Even if your mark looked
What
like.
document do you think says that? Because I didn't see that. I saw something else.
I think this is the key document.
Okay, yeah.
It is the January 10, 2017 memorandum from Mr. Colucci and Mr. Gabriel to my client on the eve of trial. It's R1459.
Okay.
And it's dated January 10, 2017. It's reviewed in my reply brief and in the primary papers. And basically, Mr. Colucci and Mr. Gabriel go over why there is a good faith defense in their view. One of their points is, yes, what you did was you complied with the advice of counsel in formatting the logo, which, by the way, had been supplied to them for prior review back in August of 2016. 2, you sought the advice of counsel.
Okay, I'll check that memo. Thank you.
So, and at the end, it goes through all of that, and then what happens? Colucci and Gabriel, with the assistance of Mr. O'Reilly, then waive this in its entirety. Now,
Counsel,
Yes,
you
ma'am.
have rebuttal. I'm going to have to have you finish up on rebuttal.
Okay.
It's okay.
If I might, seems to me that the trial court completely overlooked controlling law on this, and I will address that in my reply.
Okay.
Thank you. Hold on.
Good afternoon, Your Honors, and may it please the Court. My name is Rob Berkson. I represent the Gabriel and Pelez respondents. To affirm the dismissal of
Let me
this
just ask you this. You didn't have anything to do with were you counsel when the trial court said, precluded the use of documents that would show dilution of the mark?
Yes.
You were. So you were there at that time?
The Gabriel and Pelez was at, yes, that's when Judge Rakoff precluded that evidence from coming in.
Okay.
And the basis for precluding it from coming in was because it was submitted too late.
Right.
But that's correct. But in order to affirm the decision dismissing this legal malpractice case, the court need look no further than the appellant's use of the word velocity with their product. And it's on page 319 of the record.
But let's assume that the defense, a good defense, was that the mark was diluted, and therefore, I mean, that's what a lot of other people had argued, right? The mark was diluted. You weren't able to effectively argue that because while you did cross-examine one witness, you weren't able to put in any documents with respect to that, right?
That's correct, Your Honor. But the bottom line here is that Judge Rakoff and the jury found that this was a blatant trademark infringement on its face.
But they could have found that the mark was diluted if you had put in sufficient evidence to make out that claim, right?
Yes, that could have been.
And wasn't that exactly what you thought at the beginning of the case, that this was going to go away because the mark was so diluted?
Well, no. I mean, from trial counsel's perspective, there was a problem with that because the evidence had not been put in during discovery, and that was precluded by the court. But at the end of the day, I mean, the infringement here is so blatant. What's particularly galling about this case is that the appellants had an opinion from the Colucci firm before they started putting the velocity mark on their product, stating if you want to use this, it's got to be used in integral fashion, same size, same prominence, with the word NYNC. Okay. Clearly, they did not do that.
Thank you.
They ignored the advice of counsel, and as a result, they ended up infringing this mark. And
Thank
they
you.
don't have themselves to blame for
Thank
it.
you, counsel. I'm over here. It's okay.
Oh, I'm sorry.
It's difficult, I know.
I apologize.
It's
It's
all right,
so
I
hard
know.
with the mask.
I know.
May it please the court, I'm Anthony Green, I represent respondents Brian O'Reilly and O'Reilly IP PLLC. And I'd like to just pick up with the good faith defense. My clients were retained on the eve of trial. And when the Second Circuit went over the reasons why they found that Judge Rakoff was correct in finding that there was willful infringement on the part of the appellants, is that the district court reasonably found that the similarities between defendants' products and the Velocity trademark to be blatant. Defendants provided no evidence to explain or justify their failure to cease selling the infringing sportswear once they received actual notice of plaintiff's allegations. Now, my clients certainly had no part in the appellant's design of the infringing products or with their decision to continue selling those infringing products, and I don't believe any of the other respondents did either. And so what you're left with is trying to prove good faith, but you couldn't have had a viable good faith defense when you've got the Colucci opinion letters setting forth advice as to how to avoid infringing on the mark that the appellants failed to follow. Then the Colucci defendants refused to testify that their advice had been followed because it hadn't been. And then you had Ms. Monzina. Her deposition testimony, she said she'd never seen the full trademark search. So she couldn't even testify, they couldn't even get in the full trademark search. And it still would have been a problem that it wouldn't have shown that they followed advice of counsel or that they had not willfully infringed. And not to mention that Ms. Monzina had numerous other credibility issues. And I do want to address, to the extent the court is considering the expert affidavit, there are numerous cases saying that it's completely inappropriate to put in an expert affidavit on a motion to dismiss when it seeks to invade the province of the court, which is to decide what the legal standards are and whether they were met by counsel. This is a motion to dismiss.
What do you have to say to the argument about the dilution of the mark evidence? You weren't allowed to put it in, right?
No, my clients weren't allowed to put it in. It wasn't produced in discovery as far as I
And that would have been a complete defense, right?
I don't know if it would have been a complete defense.
Could have been.
Thank you.
Thank you.
Good evening. Ben Oxenberg on behalf of the Colucci respondents. If it pleases the court, I can address the discovery argument. There was discovery that was done. There was substantial discovery done. It's true that the actual documents were precluded at trial, but the third-party use of the weak mark was developed in both the answer and at the deposition of the plaintiff licensee of the mark. So it's not accurate to say that there was, no discovery done and a complete lack of discovery.
And just to point out, it was not permitted because they submitted it late, so the court precluded it, right? They didn't submit it as they were supposed to during discovery, so the court precluded.
That's correct, but again, the third-party use and the weak use was developed in the answer and at the deposition of.
Let me address the financial information, the claim that you should have put in financial information to reduce the number that the witness testified to at her deposition. What is your response to that?
Well, Your Honor, my response is that my clients did their level best to get that information, and that's in the very last pages of the record. My clients asked the general counsel at least 4 times over email, and that's documentary evidence, send us this cost evidence so we can reduce gross profit.
And was there anything, we don't have it, or what was the response?
Well, essentially, the response was, this is the number, which was
The one that was testified
that
to
was
at trial,
stipulated
and
to
that
at
was the
trial.
one that went in at trial,
Yes,
correct?
exactly.
There
And
was
there
no
was-
other evidence that was submitted by anyone or any evidence that was produced by anyone that
correct.
would change that number, correct?
Correct. The general counsel promised to send some other figures that would speak to costs. He never did that. In that case, my client did everything that he could do.
What about the decision to not call any witnesses? What's your response to that claim?
Well, Your Honor, my clients were a trademark counsel, and they represented RTW through the litigation, but not at trial. So I couldn't speak to that particular point.
So you're saying that claim isn't, I think that claim is pled against all defendants, right?
It may be, yes, there is group pleading.
There's a big group pleading,
Yes,
right?
and I think that the judge addresses that, but there's no dispute that my clients were not involved in the trial. And just to circle back again, I don't want to be too repetitive about this opinion letter, but my clients gave them a detailed opinion letter. They told them exactly what to do if they wanted to use this mark. They didn't have to use velocity. They could have, used a different word. They wanted to use it, and they were told that it should be defensible only if it was used in a fully integrated manner with equal emphasis on all words. And
Thank you.
None of the voices on the other side, of which there are many, at least 3, dispute that. Thank you, Your Honors.
Counsel, you're up.
Thank you for hearing me again. Several points. Number 1, the January 10th letter addresses good faith. It is from Mr. Colucci Sr., Frank, who is the elder gentleman, who basically uses the same images with different colors, tells the same general counsel, this is fine. This complies with my firm's advice. You have a good faith defense, and it's in color, and it is clearly the same as that which was sent to him for clearance by Mr. Ratner in August. So if they're shifting advice as to whether or not they complied, it's very convenient now that they say they didn't. They went back and forth, and that is precisely why Mr. Ratner asked for this meeting and asked for this memo. That's number 1. Number 2, the best evidence, in my view, not being a member of the bench, that there is at least a question of fact as to whether or not there was a waiver of the good faith defense is the fact that trial counsel, Gabriel and O'Reilly, both blame the Colucci firm for waiving that defense. In their opposition papers, they both go on in detail as to how the Colucci firm, blew it by failing to get the necessary discovery.
But the problem is, in your complaint, you plead every claim against every defendant.
I thought that we had cleared that up during the course of discovery. If we hadn't, I thought we cleared that up with Ratner's affidavit, with the expert's affidavit, and if we didn't, then there's no reason to dismiss the complaint on that basis, it seems to me. We should be afforded an opportunity to amend and clarify consistent with the evidence in the record. It's a rather draconian remedy to just tell us to leave. And finally, Your Honor, if you take a look at the answer that was filed by the Colucci firm to the underlying infringement action, It lays forth all kinds of defenses, all of which were waived during the prosecution of the case without our client's knowledge.
Thank you. Thank you all.
Thank you. Thank you. Thank you. Nice to meet you.
Yeah, that's a long one, so.